The hearing is in the matter of CFI 054/2018 before Justice Lord Angus Glennie and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Dentons & Co. Lead counsel is James Wheel. The defendants are represented by DLA Piper, Middle East, LLP. Lead counsel is Renish Petrochem QC.
Yes, very well. Thank you. We have today, I see someone estimated this case for 10 hours, but it seems to me that we should be able to. So I'm getting a feedback on my microphone. Has anyone got a phone turned on? No? We'll carry on there. It seems to me the best way of dealing with it is to give each party about 2 hours, 2.25 hours, with a break in the middle of half an hour to take stock and get coffee or whatever. Does that suit both parties?
My lord, yes, that's fine from my part.
Well, I don't object to that, but I did want to just raise a couple of procedural points before Mr. Pillai launches into his substantive.
Can I check with Mr. Pillai first whether that sort of timing is acceptable?
My lord, yes, that's fine with me.
Thank you. Yes, Mr. Wheel.
Just a couple of procedural points. You'll have seen from the skeletons that there's an issue between the parties as to the order of the applications and in particular how they should be determined. And your lordship may have seen reference in both parties' skeleton arguments to the English Court of Appeal's decision in the Pereira case. And in my submission, that judgment makes quite clear that it's appropriate to hear and determine the set-aside application in advance of consideration of any application for permission to appeal. And Lord Neuberger, in his judgment, advances a number of different reasons for that. But in my submission, they're good reasons. And the court ought to follow that course. There's no reason why the DIFC procedure should be any different. If it assists, I can take you to the relevant passages quite briefly of Pereira so you can see the sense in hearing and determining the set-aside application first.
Okay, do you want to do that then quickly?
I'll do that very briefly. The judgment is at ZZK 42.
Yeah.
This is the leading authority as to how the court should deal with parallel applications for set-aside and permission to appeal. Now, the position in Pereira was slightly more advanced than the position here, in that the set-aside application had already been determined at first instance, and the Court of Appeal was considering an appeal of that set-aside application in parallel with the substantive appeal. But nothing turns on that for present purposes, because the principles that Lord Neuberger set out apply with at least the same force to the present situation. So if I could just invite your attention to paragraph 30, and you'll see that appears beneath the heading, the interrelationship between the two applications.
Yeah.
And what the court says there is, it seems clear that we should first consider the appeal against Judge Ellis's refusal to set aside the order. If that appeal succeeds, then it would be unnecessary to consider the appeal against the order. Indeed, it would be inappropriate to do so, because the effect of a judgment being set aside is that it no longer exists, and therefore the court shouldn't waste time considering an appeal of a non-existent judgment. So that's the first reason why you should deal with it first.
That doesn't apply here, because there's no question of wasting time. We're here, we've only got today. We've got two applications. I'm certainly not going to leave it on the basis that we have another hearing of an application that hasn't been fully argued.
Well, I'll explain the other reasons and invite your lordship, if I may, to revisit that preliminary observation, because the important point, if you scroll down to paragraph 36, Lord Neuberger identifies 6 points which he suggests act as guidelines that apply in the great majority of cases. And I just want to pick up on a couple of those. At paragraph 39, beneath the letter H, about 4 lines down, it says, secondly, a defendant who has not attended trial is far more likely to have to persuade the appellate court that she should be permitted to adduce evidence or raise arguments of law not adduced or raised at trial. And then cross-reference is made to paragraphs 44 to 45. And if you scroll then down to 44, fifthly, where the defendant's CPR 39.3 application fails, she will normally be in severe difficulties in seeking to contend by way of appeal against the trial judge's order that she should be entitled to rely on evidence which was not before the trial judge. So the reason that's important is that if you dismiss the set-aside application, it's very much more difficult for the appellant then to argue that new matters of evidence, law, submission, etc., that weren't before your lordship should be entertained. And I don't know if you've got my learned friend's skeleton argument to hand as a freestanding.
I may have. Hold on a second. Sorry. Yep.
You turn to paragraph 3.3 of that document. And see 4 lines from the top of that subparagraph. It said, it's likely that if a court considers the claim by reference to legal arguments, analysis and evidence that were not raised at the hearing, the fraud finding will be rejected. So my learned friend's made very clear that his case today depends upon new matters being raised that I would say could and should have been raised at first instance. And if you're with me on the set-aside application, my learned friend should not be able to run, or at least will have great difficulties in running that argument in relation to the PTA application. So that's why it's important that you need to deal with the set-aside application first, because it sets the framework within which the argument on the set-aside application can take place. And the third point is that if the court concludes that the set-aside has no real prospect of success, then in effect that will be largely determinative, if not determinative, of the PTA application. So
can you hold on?
Sorry.
Can you hold on a second? My Teams has gone funny. It says restart. So I may get cut off. God, I have 3 of it.
I can still see and hear you clearly if that's...
I can't see anyone. I've got a blank screen in front of me. I don't know why. I can hear you fine, but maybe that's enough. But it's probably better if we see each other.
Does your lordship want to log in again, or is that
just give me a second? I've got so many Teams things on my screen. Okay, I'll have to do that. Martha, I'm going to log out and then log in again.
Yes, Judge.
Thank you. Right, that seems to be back.
I can see and hear you clearly, my lord.
Good. Let's see if this is better. Okay, carry on.
So just picking up, so the second reason that I gave as to why the set-aside application should be heard first is because that will essentially set the framework within which the permission to appeal application takes place. The third reason, and you see this at paragraph 43 of Lord Newburger's judgment, is that an application which fails on the ground that the arguments on the substantive issues have no prospect of succeeding should normally debar the applicant from raising the same arguments through the medium of an appeal. So in my submission, following that guidance, it would be wrong in principle, if not procedurally irregular, to go ahead and hear the PTA application in circumstances where the set-aside application is still live, and therefore the arguments that could be deployed in the PTA application have not been determined.
Tell me why. I can see some force in the points made, but why can't I hear both and then decide them sequentially?
Well, because then we don't really know where we stand. We don't know whether the proposed appellant is entitled to rely on new material that wasn't.
He's going to be arguing it anyway, whether he's entitled to or not. So I don't mean that rudely, but it's just arguments are always put forward on the basis that if such and such the case, then so and so.
Well, it's probably just very briefly. One can see how matters were dealt with in the Court of Appeal itself, in that full arguments were made on both appeals. Yeah. But as you can see from paragraph 30, the court was very clear in its judgment to make a discrete finding on the set-aside application first.
I don't see any problem with that. If that's the way I'm persuaded to do it.
So be it. And then I just had one further brief procedural point, which concerns the oral hearing for the PTA application. And I just invite you to consider page 574 of the Blue Book.
Yeah.
44.16 makes clear that an application for permission to appeal will ordinarily be decided without an oral hearing. Then at 44.17, the appellant may request that the application for permission to appeal be considered at an oral hearing, supported by grounds as to why it would be in the interest of justice to do so. Now, in my submission, no such grounds have been advanced. I appreciate the registrar has listed this hearing, but it would be an unfortunate precedent if it would stand.
It won't be a precedent for anything.
But
the registrar, I can tell you the registrar did that after consulting with me.
That's understood. I'm grateful. Well, all I would say finally then is that ordinarily permission to appeal applications shouldn't be more than 30 minutes, and it shouldn't be allowed to turn into a substantive appeal. But it's a matter for Mr. Pillay and myself as to how we use our respective time, and I'm certainly not objecting to an equal division.
Right, thank you very much. Mr. Pillay, is there anything you want to add to any of that? If it helps you cut things short, I'm proposing to hear argument on both, and whether I give judgment in one sequence or another, it will be a matter that I will consider when I've heard the arguments.
I'm grateful, my lord. I think the one rider, which will be clear when I get through my submissions, is simply that one of the points that Mr. Wheel has tried to make is about being cut out of putting arguments on permission to appeal. And your lordship will have gathered from the permission to appeal application that central to that is that these points should have been raised by SBM as much as anything else. Now, my lord, may I then proceed with the applications and my time estimates? I don't want to waste further time.
Yeah, sure.
Your lordship has had, I think, the skeleton argument in relation to the set aside and also dealing with grounds, and also has had the permission to appeal skeleton.
Yes.
Is it fair to assume your lordship's had a chance at least to flip through those?
You put it accurately. I've had a chance to flick through them.
I'm grateful.
But they're quite long.
Well, they are, and we apologise for that. It seemed that we needed to cover the ground properly, but I appreciate the efforts your lordship's made. I think it's probably those two documents and plus a copy of the judgment, my lord, that we're probably primarily going to be working from, if that
Right,
assists.
you just give me a second to get everything out.
I'm grateful.
I've got your skeleton for this hearing. You want the other one as well, do you?
I think, my lord, we'll probably need to flick to the permission to appeal skeleton as well.
What number is that? I can't remember.
Let me give you the reference to that. Sorry.
Is that the one of 4th February?
Yes, it'll be that.
Yeah, I'll just download that. And my judgment,
My lord, yes.
which can you remind me where it is? I was looking at it yesterday, but I can't now find it.
There is a copy at ZW81.
ZW81.
Or maybe that if your lordship's going to download it, then that's fine. Otherwise, let me give you reference.
ZW.
Yeah, no, let me because it's in the bundle in a number of places. How about ZZD1?
Yeah.
Yeah,
Yeah, just let me download it again.
perfect.
Right. Okay.
My lord, I want to make three overview comments, the first of which I'm going to develop in a bit of detail, and then turn to the tests on each application. Well, the first comment is that core to both applications is an assessment of the strength of the appellant's case. Now, technically, there is a distinction. On permission to appeal, the court considers whether there's a real prospect of success in showing the judgment was wrong. On set aside, there is a forward-looking question as to whether the defence has a real prospect of success. Well, we say for today's purposes, the standard of real or reasonable prospects of success boils down to the same level. There has to be a realistic, as opposed to fanciful prospect of success. Your lordship will be very familiar with the Swain and Hillman tests. And also that the defence carries some degree of conviction. That's from EDF, Mann and Patel. And again, your lordship will have seen that times. And all the factual underpinning for both those arguments is the same. And we say that that's fundamental. And that's why I want to unpack that a bit now. In the judgment, your lordship rightly rejected most of the allegations that were advanced in relation to the fraud. And the appellant's position is that if the correct analysis had been carried out in relation to the rump of the case, the two alleged misrepresentations said to be fraudulent, then your lordship would in fact have rejected the fraud claims outright. And my lord, the appeal ground simply explained the narrow ways in which your lordship was led into error. And this submission is not reliant on a sleight of hand. It's not jumping about the judgment to find snippets here and there. It flows from the key findings. So I'll turn to those now, if I may. And I anticipate your lordship will be familiar with the judgment.
Yeah.
But I don't propose to look at all of it. I'll be guided by the court if your lordship wants to look at specific paragraphs beyond what I suggest. So, of course, indicate. But, my lord, you'll remember that the claim was put by SBM as being a trade finance fraud, as if there was some category of fraud.
Mr. Pillai, sorry to interrupt you.
Yes.
I don't want to keep breaking off, but when I brought up the judgment, it goes to where it's now cut me off from seeing you. It's cut me off from seeing you.
Is that
I moved it to a single screen. I can't get you back on the other screen. But if you don't mind.
My lord, if I can see your lordship, so therefore I can probably keep track of whether how things are sort of landing, as it were. If your lordship's happy to proceed, I just don't want to waste the court's time.
No.
If your lordship's more comfortable with everyone on screen, which I appreciate is the best way, then perhaps we should try and log in again one more time. Because if your lordship's downloaded the judgment, then that won't be affected. Just be a question of the screen. I'm in your hands.
Okay, let's just try once more, and if it doesn't work next time, we'll give up.
Yeah,
Okay.
we'll carry on without video.
I'm going to exit.
Can I just check you can see me, because
I can see you.
okay, perfect. I think Mr. Wheel's probably here as well.
He's keeping pretty quiet about it.
Yes, I am. I'm sorry. Yes, thank you.
Okay, my lord, shall I then carry on?
Sorry about that. We'll make up time in due course.
I'll crack on.
Yep.
Where we were going was I was going to point out just the sort of key findings that your lordship had made in largely rejecting the wholesale claim of fraud, and I asked if your lordship could have the judgment to hand, and I was saying that the claim was put as a trade finance fraud. Now there's no such set piece concept in law, and your lordship had recognised that. SBM had claimed that the facility agreement and the advances were made pursuant to sham arrangements. And one can pick this up from the judgment, my lord, at paragraph 32 of the judgment, which is internal page 15, if your lordship has it.
Paragraph what?
Sorry, it's paragraph 32 at page 15.
Yeah.
And there your lordship set out the two distinct parts. And your lordship rejected the claim in relation to any reps on the facility agreement, but has held effectively that there were two valid misreps or effective misreps in relation to payment representation.
Yeah.
If your lordship looks at the bottom of 32 little 2, is where your lordship sets out the particulars of the payment representations.
Yeah.
And that goes on to the next page. And there are 5 particulars there.
Yeah.
Which are described as the purported sale.
Yes.
And then later in the pleading, if you look on, your lordship points out at paragraph 33 that the rep is then said to be false for various reasons that are set out.
Yeah.
And then at 34, your lordship summarised how this claim was being put as it all being a sham transaction. And your lordship emphasises in the second line the words "and its component transactions."
Yes.
Because your lordship was making the point that every element of the pleading at paragraph 12 was said to be a sham.
Yeah.
And your lordship rejected that on the facts.
Yeah.
And so, my lord, your lordship then went on at paragraph 44.
Yeah.
To reject the fraud case based on the facility agreement. In fact, you should look at the 3 lines above 44 at the foot of 43.
Yeah.
You see, your lordship rejected it. And you said you were struck by the number and value of legitimate deals carried out with the aid of finance provided by the bank. This is looking at paragraph 44. And in the final sentence of 44, your lordship said it's speculative to suggest it was all done to lull the bank into a false sense of security.
Yeah.
So there your lordship had rejected the facility agreement claim and rejected the notion that this was all a sham, pointed out that there were a number of and valuable legitimate deals and that there was no sense of operating the facilities in order to lull the bank into a false sense of security before defaulting. And your lordship had also, as we've seen, found that the contracts with Lanka were genuine.
Yes.
So we say that in those circumstances, and given that the court was facing an allegation that the whole setup was actually a fraud, a sham, actually by this point, your lordship had already rejected the core of the case in fraud. We go on then, because the claim was put on the basis that Prime, the third defendant, and Renish had operated hand in glove as co-conspirators. But your lordship made no findings in that regard. At 48, your lordship noted that SBM had made no positive case about the nature or extent of the alleged trading relationship.
Where is that?
It's the final sentence. This is somewhat at odds with the bank's pleading in para 5, where the bank says it has no positive case and makes no admissions as to the nature and extent of the alleged or any trading relationship between Prime and Renish.
Yeah.
Then at paragraph 53, in the first sentence, your lordship made it clear that your lordship was not making any finding about Prime being involved in the alleged fraud.
Yeah.
And then your lordship will remember that your lordship held there was no fraud in relation to the first to fourth advances.
Yeah.
So if you pause there, my lord.
Which paragraph that? I remember it, but I can't remember the paragraph.
Well, I think it's a sort of reverse analysis. If you look at 55,
you
see your lordship says it should be emphasised the inference I drew from these payments only relate only to the fifth and sixth advances.
Yes, no similar link. Yeah.
Yeah. So that what your lordship was saying there is there is a plea that, first of all, there's an overall sham. You rejected that, and you've also said that, if you remember, that the plea was that there were 6 advances, and all of them, each of them was induced by a misrep.
Yeah.
And your lordship's rejected that in relation to each of the first 4, but it has held that there was a misrep in relation to the 5th and the 6th. And so before I get to why your lordship held that there was a misrep in relation to 5 and 6, I just want to pause here and say that your lordship has actually dismantled the fraud claim as it was put. Your lordship's findings actually blow a hole through all of paragraph 12, which is their key pleading on the payment representation. And your lordship's rejected the claim that 4 of the 6 advances were fraudulent or induced by a fraudulent misrepresentation.
Yeah,
so it's pausing there. And what I say is your lordship's findings reflect a linear progression. So I'm not island hopping here. I've just taken your lordship through it. And we say that there's a real prospect of success in defending the claims, because once the court had rejected the overall sham transaction argument, rejected the lulling into a false sense of security argument, and found that there were no misrepresentations in relation to the first, second, third, and fourth advances, there's actually no factual or legal basis for finding that the other representations or alleged representations were actionable or that they were false. I'm going to break that down by reference to the legal test and the facts, because what's important at this point was that your lordship then had to look at the 5th advance in its context and say, was there an actionable representation? And look at the 6th advance and ask, was there an actionable representation? Now, I'm just going to, and what your lordship did, since we're here, it begins at paragraph, the analysis of the payment representation for fraud begins at paragraph 48, which we were just looking at the bottom of.
Yeah.
And your lordship had referred back to the pleading. But then there is no analysis of whether there was a representation made. What your lordship did at paragraph 50 was to focus on evidence as to dishonesty. So if you say there's other evidence which is admissible and compelling, the case plead in 55 to 59 is to the effect that monies received from the bank by Prime, pursuant to request by Renish, were within a matter of days dissipated for no obvious legitimate commercial reason. So essentially, and then you went on to say the inference ought to be drawn as that these payments constituted a means of dissipating monies pursuant to the fraud. Okay?
Yeah.
Now, and then you said, I found as a fact these payments were made. And then you went on to say Mr. Mehta had offered no explanation. And had there been a proper explanation, I don't know why it wasn't given. So therefore, you said, I accept the inference sought to be drawn as far as it relates to the fifth and sixth advances. And what your lordship has done there, with respect, and which wasn't pointed out because your lordship wasn't taken to the proper test in this context, is not consider, well, right, was there a representation made in the context of a utilization request and in the context of the fact that I've said that everything else was legitimate? Your lordship has said, essentially, the fact that payments were made out by Prime shortly after an advance was received from the bank has not been explained to me. And that was a particular as to dishonesty, and your lordship has applied it as somehow supporting the existence of a representation in the first place. Your lordship will be alive to the fact that, firstly, was there a rep? Was it actionable? And was it false? And your lordship has taken the particular as to falsity, you know, what was presented to you as a dissipation, which is already a pejorative way of looking at it, but a payment out, and said that supports the existence of a representation. And we say that that's wrong.
Where do I say that?
Where do you say what? Where do you say that?
You say the falsity supports the existence of the representation.
Your lordship doesn't say that in terms. You say that you accept the evidence as to the fifth and sixth. So therefore, at 51 in the middle, absent any explanation from Mr. Mehta, I accept that inference ought to be drawn so far as it relates to the fifth and sixth advances. Yeah. These payments are characteristic of illegitimate and fraudulent trading, and the timing speaks for itself. So your lordship was impressed there by Mr. Reed's argument as to the fact that the timing of the payments was put as suspicious. But the fact that a payment was made out from Prime doesn't mean that a representation was made.
I think, if I may say so, I may not have expressed it as fully as I should have done. I have accepted in paragraph 48 that there was a representation that the payments were required to fulfill genuine bona fide commercial arrangements.
Well, my lord, that of itself, your lordship had to find that there was an implied representation,
yes,
that was actionable by reference to the full test. Your lordship, I think, said essentially one has to look at all of the circumstances. But what your lordship then didn't do was actually take into account all of the relevant points. If your lordship looks at 27 of your lordship's judgment,
right?
Because what the case was put on implied representations, yeah. And you were referred, my lord, as part of this trade finance allegation, fraud allegation. Your lordship was referred to Corinth Pipeworks.
Yeah.
And your lordship rightly said, well, that may well be so, that, you know, that was the case in Corinth, but it all depends on the particular facts and circumstances.
Yeah.
And that was it, my lord, for the test, for the legal analysis on the test. And can I then just take your lordship to Corinth Pipeworks?
At risk of losing connection, but yeah.
Oh, well, I mean, if your lordship doesn't need to download it, perhaps if your lordship just clicks on it.
It's easier said than done. By the way, I've lost your picture. If you don't mind me listening to the argument without seeing you.
I think we can't risk.
I don't want to risk that again.
We probably can't risk it, my lord.
I can bring Corinth up there.
Okay, I've got it at ZZI. Yes, ZZI.
What number?
Page 15.
What number?
20. Document 20. Lordship have that?
Yeah. Right, I've got it.
No, that's a first instance decision. Went on appeal on a different point, but that's Justice Sir David Steele's decision.
Yeah.
And the paragraphs that are relied upon are essentially at 84, which is page 1626.
Yeah.
If your Lordship has paragraph 84, all this is just setting out what the claimant's case was in that case.
Yeah.
There was and it said, they had a payment representation there, and that money was going to be used in relation to trade finance. And then do you see that there's no consideration of a test?
Yeah.
It's just a recitation. And then at 89, there is a conclusion about reliance on what was being said. And Sir David Steele gives an example which is not related to the present context about a vendor of goods relying on implied representations.
Yeah.
Although we say that doesn't set out any test or principle or anything. And it's also a case, if your Lordship goes back to the first page of the decision, where it was one-sided. And it appears it was just Mr. Taylor QC who attended, no representative attended on the Part 21 defendant.
Yeah.
So, we say that really certainly doesn't establish there being a wholesale trade finance fraud. So if your Lordship could then look at document 5 in the same bundle, it's called Casa di Risparmio.
Yeah.
Now this is cited in our skeleton argument, but if I take your Lordship to this, I think it's all in here. This is a decision of Mr. Justice Hamblin, as he then was.
Yeah.
Trying to scroll down to the relevant section.
You want to hear the judgment or your skeleton?
No, judgment's fine. I'm just trying to get to the right paragraph, which is 215. That's what the legal analysis begins at 215. The relevant part for us begins at 220.
Yeah.
And my Lord, this really sets out what your Lordship should have been invited to consider, and then goes to what I was perhaps inarticulately trying to explain to your Lordship about the relevant stages your Lordship had to consider in relation to each of the 5th and the 6th advances in the context of what your Lordship had already found, which is to reject essentially the pleaded case. So your starting point is a 220, is a well-known dictum of Mr. Justice Toulson, first instance in IFE, that you have to look at the context and whether someone with the known characteristics of the actual representee, SBM, would reasonably have understood an implied rep was being made substantially to the terms or to the effect alleged. Okay, now that sort of, my Lord, we say it is broadly covered in what your Lordship had put at paragraph 27. Look at all the facts and circumstances. Yeah. But then, my Lord, in a deceit case, I'm moving on to 221. It's necessary the representor, that's Mr. Mehta here, should understand he's making the implied representation and that it had the misleading sense alleged. The person cannot make a fraudulent statement unless he's aware that he's making that statement. And then the final sentence is also relevant. In other cases of misrepresentation, this is not a requirement. One generally expect it to be reasonably apparent and so on. And also 222, it is necessary for the statement relied on to have the character of a statement upon which the representee was intended and entitled to rely. And so, my lord, that then is very important to bear in mind, because not every expression of intention or contextual matter gives rise to an actionable representation. And since your lordship is looking at the documents, there's one other reference that it's worth picking up, which is the Springwell decision. That's at tab 9 in that same bundle.
Mm-hmm.
And if your lordship could look at paragraph 669, that simply just to, again, demonstrate the nature of the exercise that has to be carried out.
669.
Yeah, it's paragraph 669.
Any idea what page?
I'm going to get you there, my lord. My highlights are somewhere. 777. And it's just it's at the foot of the page.
So what internal? Oh, sorry.
Internal page is 256.
Yeah.
And the point that I'm referring to is that there, in the exercise of applying IFE, the judge considered the question of what actionable representations, if any, were made, has to be considered by reference to the relevant provisions in, and then lists various contractual documentation that was context. And all this goes to show, my lord, for present purposes, and again, for one, if one's considering whether permission to appeal should be given, is that the context to your lordship's analysis of the alleged representation for the 5th and 6th advances also included the contractual material and detailed analysis of intention and knowledge on the part of both sides, and whether it was reasonable for there to be said to be implied representations given the suite of contractual representations that existed here. And I've dealt with the contractual representations in the skeleton argument, in my permission to appeal skeleton argument. Perhaps it's worth looking at that if your lordship has that to hand, or opens another tab, I'm sorry.
Yep. This is the one which is ZZC12, is it?
Yes. And I'm looking at internal page 29. And I take your lordship to this only to point out,
Oh,
your lordship.
What? Internal page 29.
Yeah, paragraph around 66.
Right, sorry, yeah. Yeah.
And so at the foot of 65, I make the point about how evidence was applied as to whether an alleged representation was fraudulent or dishonest to determine whether there was any actionable rep in the first place. 66 sets out, what contextual material had to be set out, and that's where, and then we cite skeleton argument 67, various of the contractual provisions.
Yeah.
And then at 68, we say, and again, I say that there's for now, there's just the real prospect of success on this point, but that if your lordship had been given the proper test and applied it, then your lordship would have held that actually, well, all that's being, these alleged implied representations are not actionable at all, because what was relied on by SBM was a utilisation request for drawing down funds. And you had a contract, and you wouldn't reasonably have considered there to be a separate implied rep of any sort, but certainly not this sort. And in any event, there's no finding and no basis for finding dishonesty, because the defendants wouldn't have, the appellants wouldn't have understood that they were making any sort of representation beyond the contractual representations. But the point here is that your lordship wasn't taking to any of this. The judgment, well, and it's clear from the submissions and the skeletons that your lordship, this wasn't raised with your lordship, and therefore the judgment doesn't reflect that sort of analysis. And what there was, my lord, just to go back to the judgment, and I'm just trying to scroll down to it, I apologise.
Yeah.
At paragraph 55, is your lordship sort of tied together the points about the 5th and 6th advances? And your lordship said that there was no similar link in terms of timing to justify a similar inference of fraud in relation to, in respect of earlier payment. Your lordship see that in the middle. Now, my lord, firstly, we say that there's a further error there, because actually there were payments in relation to the 4th advance to Renish, but your lordship found that that was innocent. So we don't understand how that's correct. But also the real point, particularly which is drawn into, would have put into stark relief by the authorities I've just taken your lordship to, is the penultimate sentence where your lordship says it is idle and impermissible in the absence of evidence to speculate on what may have occurred to alter Mr. Mehta's intentions in relation to his dealings with the bank. Well, my lord, actually that begs the question that your lordship had to answer had your lordship been directed to the proper test.
Why?
Because, well, for this reason, your lordship has found that there wasn't a sham, there wasn't a lulling attempt to trick the bank. Your lordship found that there were 4 proper advances, therefore no misrepresentations. So, well, in that case, where is the intention consistent with the Rispamio test about the intention to make a rep and therefore intention to deceive? Your lordship actually just says, I'm not going to speculate how that intention is. And we say, actually, what your lordship has done there, because your lordship was led into error, was not to investigate the very points that your lordship had to investigate.
You don't have to motive.
No, but your lordship had to find intention, and your lordship hasn't even gone near intention. You said, I'm not going to speculate what occurred to alter an intention, but your lordship hasn't actually assessed what the intention was.
Well, the intention is somewhere back in the judgment, where I agree I don't go into the detailed analysis that you say I should have done, but I accept that there is a, sorry, there's an echo again. I accept that there is a representation that payments are required for bona fide trade. Sorry, I'm putting it badly, but somewhere in the judgment it says that.
I think your lordship has in mind that paragraph 48.
48, thank you.
I think your lordship says that the allegation is that.
Yeah, but I think it's pretty clear from what follows that that's the allegation that I've accepted.
Well, my lord, that may well be plainly is your lordship's intention in that analysis, and we say that actually, if it had all been analysed fully by reference to the proper test, there's a real prospect of success on the argument that there wasn't an actionable representation, and I don't put it further for now. But
you seem to think I should have gone into tried to understand Mr. Mehta's motives in changing his intentions.
My lord, what I'm saying is that your lordship should have analysed and made findings in relation to whether it was an actionable representation. And in relation to that, your lordship had to assess intention and knowledge, and motive would have been contextual to that at a minimum. That isn't there, my lord. And particularly what your lordship would have had to do was say, how is there such an intention given that everything else was not fraudulent? So, and that isn't there, you see, my lord. What's happened is that... Well,
sorry, can I just
of course.
I just want to be clear that I understand your point. As I understand my judgment, it's always a dangerous thing to try and understand something you've written yourself. But as I understand my judgment, I am impliedly, perhaps I should have done it more expressly, but I'm impliedly finding that there was a representation to the effect that payments were required to fulfill genuine bona fide commercial arrangements for the purchase of oil from Prime and the shipment to Sri Lanka. What I then find is that as regards the first 4 payments, there was no fraud, no dishonesty. Not that I don't say there's no representation, but I find there was no dishonesty because they were, as far as I could see, part of a genuine bona fide transaction. With 5 and 6, that position changed because the money was just taken straight out. So I'm trying to summarize rather crudely my reasoning. And that is what changed rather than the question of whether the different representation was made.
My lord, well,
more complicated than that.
Well, my lord, firstly, with respect, and of course, you know, it's always difficult and invidious to be debating it out with the writer of the judgment. We say that reasoning isn't clear, but secondly, is not premised on applying the correct test, and that of itself is enough for there to be a real possible success on this point.
I can see in some cases going through the stages of the test may be important, but surely it's pretty obvious in a case such as this that there is a representation that payments drawn down are required for bona fide transactions.
My lord, we'd say that's not obvious, and in fact, if your lordship is going to go down that route, then that's to fall into the trap of there must always be a rep like this in a case like this, and actually your lordship rightly disavowed that submission based on Corinth, which certainly doesn't found that submission in any way.
Right, okay.
But my lord, but there's this further point, which is that your lordship also didn't pause to take into account, and again, relevant to the point about motive, but your lordship has to consider the inherent probabilities as to whether there is a fraud, and your lordship had to consider that in the context of each of these representations, and that again involved taking stock as to how much of the claim in fraud had been rejected, and also looking into the material, the evidence about the appellant's commercial standing and their motivations and likely intentions. We say it's highly unlikely that they would enter into fraud in circumstances where they were pinned with contractual liability, likely to lose their assets, business and standing in Dubai, in the place where Mr. Mehta had built his family and commercial life. He wasn't going anywhere, and he'd signed up to all of this contractual liabilities his company had, and he had a personal guarantee. And your lordship has seen that it's on the record there's a large judgment against it. So, my lord, that's also relevant not only to the context, but also to that specific point on which I said begged the question, because your lordship hasn't paused here to look into the inherent probabilities, and there's a lot of noise about standards of proof. There's no distinction. There's one civil standard of proof. It's a balance of probabilities, but of course, central to that analysis, any court will look at the inherent probabilities.
Yeah.
And there isn't, with respect in the judgment, a consideration of that. And further, your lordship had rejected Mr. Mehta's account on the basis that he should have given a full answer if he had one, and that there's a point about reversing the burden of proof there. But what your lordship wasn't taken to at trial was the corroboration as to why these payments were genuine. And that's corroborated by Prime's defense. We can look at that at ZZD. 3 at 65. I'm trying to get that up.
Yeah.
There's document 3 in there. I think it's page 65.
Mm-hmm. Yeah.
And para 51 just makes the point that the payments made by Prime were genuine and to a legitimate party, because there was this, the point was that there was the payments out of Prime, which is what your lordship has relied on as establishing a misrep, as it were. So
No, not establishing a misrep, establishing the fraudulent conduct.
well, my lord, we need to break. What does your lordship mean by that? What your lordship means is there was a representation and it was false. It was fraudulent. So
Yes,
therefore, that's why I refer. I'm sorry.
The payments out of Prime go to the question of whether it was false in the particular case,
Exactly.
rather than as to whether it was made.
Yes, but so we're moving on here because I'm moving to the point about if you're considering that it's fraudulent,
Right.
then you've relied on the fact on a timing point, and what Prime's case is that all of these payments were genuine and were for genuine purposes, because your lordship said there's no explanation for Mr. Mehta. Well, his position was corroborated by what Prime said. Prime's expert also looked at these payments. If your lordship looks at ZZF.
But that wasn't evidence in the case.
Well, my lord, it was evidence that your lordship in the judgment said should be raised if it undermined any aspect of SBM's case. So
where did you say that?
Well, you say that.
You may be right.
Yeah. If we look at it, so looking at these points about evidence in the case, your lordship first looks at paragraph 24. So you start at paragraph 24 talking about factual witness statements.
Yeah.
Does your lordship see that? And of course, there was a peculiar situation because at the hearing, Mr. Reed tried to rely on it sometimes. And if you see at the foot of page 11 in the judgment, there's a paragraph. Mr. Reed appeared at times to accept such evidence not been formally adduced. At other times, he sought to rely on it.
Yeah.
Okay. So now your lordship then said it's not been formally adduced. If it's put in as hearsay, that's one thing, but they weren't. But then your lordship says that is not to say that they're wholly irrelevant. They might directly or indirectly raise questions about the claimant's case or identify weaknesses in it, which ought to be addressed.
Yes.
Okay. So that's what you say about factual evidence. And then in relation to 25, you talk about expert evidence.
Yeah.
You see that?
Mm-hmm.
And then again, in the final sentence, you say, accordingly, as with the defendant's witness statements, his report, as Mr. Drew's report, had no evidential status and was relevant only to the extent of providing the context for some of Miss Lavin's evidence. Well, my lord, I think that in a position where you have these statements and you've expressly said, well, if it directly or indirectly raises questions about the claimant's case, i.e. what your lordship was being told, which ought to be addressed.
But it remains the fact that it's not evidence.
Well, my lord, it's difficult for you to say, on the one hand, it's not evidence, and the second hand, that's not to say they're wholly irrelevant. Your lordship.
The distinction I was intending was I think one that I've always understood to be the case, that if points are raised, matters of argument and so on, they should fairly be taken into account. But you don't have to bring in the other side's potential evidence if it's not adduced.
Well, my lord, first I point out, actually on the face of it, this falls within a document that identifies weaknesses in the claimant's case, which ought to be addressed. Okay, and my lord, none of this was raised with your lordship at the time, and that's particularly egregious because in the same breath, SBM were trying to rely on other bits of this material, which is the point that your lordship made. So in those circumstances, not only was the pleading relevant, but your lordship should have been taken to and should then properly have considered, because it raised a weakness which ought to be addressed in the claimant's case. Your lordship should have been asked to consider this in relation to both the expert evidence and the evidence of Mr. Sadder on this point.
Okay.
And you've got references in the skeleton argument on that. But again, this we say goes to real prospect of success, that there is corroborative material that should have been raised. And so, my lord, what we say is, if your lordship had been taken to the proper tests and had raised with him these matters which identified weaknesses which ought to be addressed in the claimant's case, there was a real prospect of success, both on appeal, but also in relation to defence. Respectfully, I say that the error in your lordship's reasoning and conclusions came about in part, at least, because you weren't properly assisted by compliance with the duty of fair presentation. And that's a well-established duty.
Do you say the duty of fair presentation goes as far as the party that is represented or is present actually adducing evidence against this case?
My lord, I do, yes. Can I take your lordship to the... I delve in the skeleton, but the best thing is just to look at the cases. It was summarised most recently in the CMOC case, which is at ZZI.
I have it.
6.
Yeah.
That was a case where it was a one-sided trial in relation to fraud, and various payments have been extracted through email push frauds. If your lordship looks at paragraph 14, internal page 4.
Yep.
And it's a paragraph that begins, where the trial is not attended by one of the parties, there's still an obligation of fair presentation, which is less extensive than the duty of full and frank disclosure on a without notice out. And then he cites Mr. Justice Cresswell's decision. What it says is that Mr. Justice Cresswell required the claimant to draw to the attention of the court points, factual or legal, that might be to the benefit of the defendant. So pausing there, I say that everything that we have just canvassed in that trot through the judgment, which has also effectively covered the grounds of appeal, are points that would have been to the benefit of the appellants, the defendants, and should have been raised with your lordship. And, my lord, these were not abstruse. Sorry.
There seems to be that falls short of saying that there is an obligation on the party that is present to adduce evidence against its own interest.
It's not to, well, my lord, it's not to adduce it. It would have been to point out, just in the wording of your lordship's own analysis, it would have been to raise questions. It would have been to identify to your lordship questions about the claimant's case and identifying weaknesses in it, which ought to be addressed. That's referring to your lordship's own words.
Yes,
and
but
then,
sorry,
yes,
the distinction I'm trying to draw rather clumsily is this. If, for example, by reference to Mr. Sardar's affidavit, there had been a point raised that, well, Mr. Sardar says it was all bona fide payments and so on in the ordinary course of business, where would that get anyone? Because Mr. Sardar's evidence was not taken. All you have then is a question raised in the abstract. Well, is there a defence that it was all in the course of business? But there's no evidence to. Mr. Sardar's statement is not evidence. Mr. Mehta didn't give evidence. So where is the evidence on which any question can be legitimately considered?
Well, my lord, I think it would follow in this way. Is there evidence on the record? Sorry, is there a reason is there a material that raises indirectly or directly questions about SBM's case or identifies weaknesses in it?
And the answer
Yes,
is no.
Sorry.
The
Well,
answer
no.
is no.
Well, no,
Because
my lord, I'm afraid you're actually it's entirely circular what your lordship's suggesting, because you're saying that on the one hand, your lordship's own judgment says that if there's matters that need to be addressed because they raise weaknesses in the case, how else are they to be addressed? Because your lordship is essentially says, well, there is a document or there is evidence that raises a weakness in SBM's claim which needs to be addressed. But and you recognise that. So we say, let's say there's expert evidence of Mr. Drew and witness statement evidence of Mr. Sada, which raises a weakness that ought to be addressed. Your lordship can't then in the same breath say, but it can't be addressed because this is hearsay and therefore hasn't been adduced. The answer to your lordship's question must be this, is that if there is material that hasn't been adduced because it's Prime's evidence, then but it raises a question because it's a weakness, identifies a weakness in SBM's case, then it has to be admitted as hearsay and the court has to take it into account. So the first thing is it has to be raised, because that's what your lordship is saying at the end of 24. And then at that point, the court has to admit it as hearsay evidence. But that's not, I don't think that's a particularly controversial point. But otherwise, there is no actual mechanism, because your lordship is taking this evidential rule point, which I understand, but there's no mechanism for directly or indirectly raising questions that ought to be addressed, because your lordship would say, well, I can't address it because it's hearsay, so there isn't evidence before me on it. So that's why I say it's entirely circular.
it's nothing to do with it being hearsay. It's to do with it not being evidence at all.
Well, but my lord, if it was not, I'm afraid that the same point comes to it. It's not evidence at all. Well, in which case, what does your lordship do with it? Your lordship is saying it must be raised. And I'd say that your lordship in those circumstances is taking an entirely formalistic approach to this aspect, because it's plain that, as Mr. Justice Cresswell has pointed out, you have to bring out points, factual or legal, that might be to the benefit of the defendant. And in that, I'm just going on in the rest of CMOC, you had to bring to the attention of the court points which the defendant had taken before it decided to play no further part, and also points which it had never taken, but might have taken had it decided to defend the proceedings. And
Yes. Okay.
so, my lord, even then, the second point that I've just read plainly applies, because had Mr. Mehta attended the trial, then this is something he was likely to have wanted to rely upon. And at that point, if he'd attended in person, then your lordship would have had to, presumably, and we'll come to how to deal with the litigant in person, but would have had to take appropriate steps to have that admitted if needed, and otherwise have it tested or otherwise take it into account. Because going back to where I started on this, my lord, your lordship's found that these are payments that you say didn't have a legitimate explanation. Well, the party that settled out of the case on the eve of trial said that they were all genuine. And it said so in a sworn pleading, it said so in a sworn witness statement, and it said so following analysis from its expert, Mr. Drew.
Mm-hmm.
Okay. Now, against that, your lordship was faced with SBM saying these payments are a dissipation. Look how quickly they went out. That must eventually be dodgy and is a basis for your lordship to find a fraud. Now, okay, so against that assertion, you have these three limbs of evidence, plus what your lordship said was an inadequate explanation from Mr. Mehta, but he's put it forward. You have four then parts of evidence which plainly raise a weakness that ought to be addressed. And that is a weakness that ought to have been addressed at trial and would be addressed in any future trial. And what we say is your lordship didn't have it before him because your lordship's not going to have sifted through the evidence in that detail, but SBM did. And the fair presentation requirement that I've referred to here plainly countenances that it should have been brought up with your lordship, and it wasn't. It wasn't brought up in the transcript, and therefore it's not reflected in the judgment. So, I mean, I think that's sort of the beginning and end of that relevant point of defence not being raised as it should have been. And the laws, so that covers the factual substrate underpinning both the legal text. That was my sort of headline opening, but I think that really covers from soup to nuts the core of what we're going to do. And so therefore I'm going to have to take inevitably the rest of this rather quickly because we've had some stopping and starting. Well, the second comment that I was going to make was that the contractual framework.
As regards timing, we lost 3/4 of an hour or so this morning, so you can carry on beyond what it would have been about 10:15. You can carry on till 11 if that helps.
My lord, I think that may help, but I anticipate what we're going to get to is that it'll be a bit of repetition, so I think we'll avoid that. But I'm grateful for that indication. So yes, my lord, second comment was about the contractual framework having resonance beyond the need for consideration on the misreps. And it's simply this, it's that the contractual framework is the basis for the fact that SBM has a money judgment for $31 million. So the court now should not be asked to be providing declaratory fraud judgments. And what's the concern here, not only that it's a waste of resource and court process, but is that the context in the UAE means that it might be used as a threat to provoke local criminal actions if Mr. Mehta returns to the UAE. Now, he's explained his concerns about this in his evidence. He's not been able to come back from India. And therefore, it's a proper concern that this court should be alive to avoid a collateral improper use of court process in the circumstances. Your lordship asked Mr. Reid, why are you doing this? And there was an explanation about enforcement, but it's not clear why there is an enforcement advantage. There's a freezing order in place. If they want a post-judgment freezing order, they can apply for a post-judgment freezing order. But there's no need for a fraud judgment to use up the court's time in these circumstances. And the third comment, my lord, is that obviously your lordship will have gathered that Mr. Mehta is appearing here and issued 2 applications, having finally obtained some funding, to defend the claims and clear his name. My lord, and he does so having had his business and life sabotaged in a way that few can contemplate. He's not gone to ground, and he's not ignored the court's order and judgment. And my lord, you've been told about the act of sabotage, and you've recorded it in the judgment as part of a sequence of facts that was not seriously challenged. So there's nothing in the factual findings from the trial that contradicts Mr. Mehta's account. I can just make that good. Yeah. If your lordship looks at paragraph 6 of the judgment.
The truth of Mehta and all that.
Well, paragraph 6 is just where you start by saying the outlined facts are not seriously challenged. Yeah. And then he talks about the truth of Renish at paragraph 11. That's just to make those points. Well, I do deal with this in the set-aside skeleton argument. Your lordship may have seen that. Yeah. There's a section at paragraph 8 onwards. But look, most of the applications that were made for adjournments were caused by Mr. Mehta seeking to get funding to get on a level playing field. It would have been preferable and courteous if Mr. Mehta had appeared on the 6th of October to explain his concerns insofar as he could articulate them about fairness of the procedure. But in the event, it's unlikely any of that would have made a difference at trial because your lordship had given only a 2-day adjournment to proceed. And I'm going to come on to that.
I wasn't asked for more on a subsequent occasion.
Well,
Mr. Mehta wanted 6 months or thereabouts, but having given 2 or 3 days, if he had come back on the 6th and need another days, I don't imagine that would have been refused.
Well, my lord, I think he asked I think, till the beginning of 2022, but we will come on to all of that, and I understand hear what your lordship's saying, because what I say here is that the court shouldn't be swayed by sort of ad hominem criticisms attempting to portray Mr. Mehta as a serial wrongdoer. It's an exceptional situation that we're facing on the evidence here. It's a skeleton argument, paragraphs 8 to 14. It's just appropriate to redress the balance.
So which skeleton is this now?
It's the set-aside skeleton.
Right. Hang on a second.
It's the other long skeleton, I'm afraid, my lord.
It's the what?
It's the other long skeleton.
Yes. Give me 1 second.
Of course.
It's not a combined one.
Well, it sort of is combined. It's
For hearing of the appellant's application for permission to appeal and decide the order.
yes, paragraph 8 of that. Oh well, it's sort of section is 8 onwards. I don't mean to. Your lordship can flick through it, but
I see. Okay.
yeah, that's just to put some context on this.
Yep.
So, my lord, then there are two applications, and let me deal with the set-aside application, if I may. Your lordship has the skeleton we've just been looking at. I'm going to follow that framework, beginning at page 8, para 15 onwards.
Yeah.
So the context that your lordship will probably picked up is the rules at 35.16 to 35.18.
Mm-hmm.
And for 35.18 has the 3-stage test.
Yeah.
And these conditions mirror the English CPR. And there are 3 elements to them: promptness, good reason, reasonable prospect of success. And my lord, as to the test on promptness, we quoted there at paragraph 17, is that doesn't mean that the applicant has been guilty of no needless delay, whatever, but rather that he has acted with all reasonable celerity in the circumstances.
Yeah.
I don't think I need to take you to the case on that. And then the second point is as to good reason. And we say that there are the key aspects of that, if I can just summarize them for your lordship, and then we'll look at the 2 cases. Key points, we say, are that your lordship will not adopt a very rigorous approach in considering the applicant's conduct. If the 3 tests are met, then it's exceptional for an order not to be set aside. The approach is different to and more generous than when considering whether to adjourn, and your lordship's not fettered by any exercise of previous exercise of discretion.
I wanted to ask about
yes.
that, which I find puzzling for this reason.
Yes.
If the test for adjournment is stricter, then it seems to lead to this consequence. A party comes along saying, I can't get legal representation, I want to adjourn. I'm put it wrong. I want to adjourn. The judge says, no, you've had every opportunity. Okay, so I won't adjourn. He can then, at the end of the trial, he walks away. At the end of the trial, he can come and say, I couldn't get legal representation. I asked to adjourn, that was refused, so I didn't turn up. And a more generous approach is taken then. Is that right?
My lord, yes, that's right. Because
so he gets his adjournment, but only.
Well, he may do. It'll all depend on the facts of the given case. But the reason for that is that what your lordship is then doing is effectively meaning he's got no right to have his case heard at trial. You've closed him off. We can pick it up in the decision of.
He can appeal the refusal of the adjournment.
Well, but normally the position is that you should not appeal the refusal of the adjournment, is that if you don't go to trial, you should appeal, you should apply to set aside. That if you look at Pereira.
Sorry, I can understand I could understand if the degree of strictness was the same on the two applications, but I simply can't understand why it's more generous to a party who comes along having walked away than if he had applied for an adjournment.
Well, I think the reasoning is that of Lord Justice Dyson. So perhaps we could, or Lord Dyson, Master of the Rolls in Moore and Smith.
Yeah.
If your lordship has,
I've got it. Paragraph 20.
Well, it's paragraph 20 of the skeleton. Yeah.
That's good enough.
Yeah. Yeah. Well, it is good enough. Yeah. And that's the point, because he says if. It's exactly there, my lord, and that's the reasoning, and that's high authority for present purposes. Because if your lordship closes this out, then on that sense, the risk is that there will have been no opportunity for adjudication on the merits.
I didn't understand, sorry, it's my fault, but I didn't understand this point about no opportunity. There was the opportunity by turning up at trial.
Well, there's the opportunity of turning up at trial, but if your lordship but it's more generous now. So it's strict for adjournment, because there'll be a trial, but it's more generous for the set aside, because the consequences of the set aside, if it fails, is that, and this is where the quote says, but if the application to set aside a judgment under 39.33 fails, the applicant will have had no opportunity whatsoever to have an adjudication by the court on the merits.
But he will. He didn't need to walk away when his application.
But that's gone now, and the point is, my lord, it is, because I can't redo the adjournment. And the proper approach is.
Sorry to talk across you.
Yes.
I'm just thinking what Lord Dyson's saying.
Yeah.
He says if the application to set aside okay. If the application for an adjournment fails, the party can decide or to walk away. So he has an opportunity then to have adjudication by the court on the merits.
He has an opportunity, but if the adjournment isn't given and he doesn't attend, then the point is that now it's essentially last chance saloon, subject, supposed to appeal from this. But there won't have been an opportunity. That 39.3 is a safety net that allows the merits to be put. The merits of the defendant's case, look at this case. The merits of the defendant's case have not been tried fully by this court, partly because all of the points were not put before it, which should have been put. Well, your lordship,
you're jumping a stage. They haven't been put because the defendants chose to not to take part after the first day.
Well, I mean, they didn't attend the trial. They attended the hearing on the first day. But of course,
he attended the trial. You're not making a point, are you, that the first day wasn't part of the trial?
Well, there is a slightly astonishing point that was put by my learned friends, which I'm going to come to, that he didn't attend the trial, but that he did attend the trial. My lord, is pretty clear from the judgment and also the transcript that he didn't attend the trial. But
you'll need to persuade me on that.
Well, okay, we'll come to that. Well, the point on this legal analysis is that on adjournment, there could be a trial where the defendant's case is put on the merits or not. If he doesn't attend, then he has the court has the fallback of section 39(3) to decide, because that's the last chance saloon.
Yeah.
And I think the answer to your lordship's concern is this, is that you don't just willy-nilly get allowed back in. There has to be a good reason. And so therefore the court has to consider what's being put forward here. If the court thinks there was a good reason on reflection for non-attendance, then, and it won't take a very high bar on looking at that, then it will allow the court back in. And the reason for that lower bar, or a not very rigorous approach, I think is the phrase, is that the consequences are so severe. Okay, because what your lordship, if your lordship was not to set this aside, alternatively not give permission to appeal, because on here we say that position effectively should be equivalent. But if your lordship didn't do that, then the merits of the defendant's defences have not been tried, and that's a fundamental right. And we know that the DIFC court, just as the English court and the Scottish court, would uphold those rights to a fair trial. And what we say here are that there is a good reason for not attending, and therefore the set-aside test would be met. So that's the legal context. Well, the Pereira case I've cited at 24, well, 19 onwards, and plainly it says you've got the point about the court should not be very rigorous when considering the applicant's conduct, and also should not prejudge the applicant's case on the factual merits for the third test. So I don't think I need to take your lordship to the test, to the cases further than that. I've tried to set it out at some level. I think there are also three questions about fairness and fair trial, which are important for your lordship to bear in mind here, because the essence of the point is that it appeared to the defendant that he wasn't going to have a fair opportunity to present his case on the basis of the two-day adjournment. Now, the first context to considering fairness is, of course, the overriding objective. Your lordship will be familiar with that, which is that the court must deal with the matter justly and fairly, and that, of course, applies to both contexts. That of the claimant and, of course, the defendant, who is a litigant in person. And the second source of context in relation to fairness is, we say, the considerations in the Equal Treatment Bench Book, and that's at ZZI 1036. Does your lordship have that? I don't. Is your lordship familiar with this?
Well, I've seen similar things. I don't know about this one.
I'm grateful. Well, this, if you look at from the first page, is the February 2021 edition. So that's the revision. And perhaps if we could just start with the introduction, which is page 1059. I'm afraid I'm a bit slow on getting around this document. You see the foreword, my lord, so it highlights that this is a key work of reference used daily by the English Welsh judiciary, said to be admired and envied by judiciaries across the globe. Now, what I don't know is whether there's an equivalent for the DIFC judges, but no doubt the best practice reflected here is something that will be reflected in the DIFC as well. So, which is why I raise this at all as being relevant. And then at page 1063, is the introduction, There's obviously paragraph 51, paragraph 1 about fair treatment, which the court will be familiar with. And paragraph 2 deals with the force, as it were, of the bench book. And it's, we say again, that would be relevant guidance to be taken account by this court. I've cited a case in which one can see how the English court deals with it, which is Williams and Nielsen, which is tab 16, but we don't need to turn that out, but it's just an example. And then in relation to the next page, paragraph, page 1064, under the section good communication, I just want to pick out paragraph 16 about, effectively, it's about empathy. Judges should try to put themselves in the position of those appearing before them. An appearance before a court is daunting and unnerving, and so on and so forth. And it's all about communication, in essence. And on the next page, my lord, there's a paragraph about lay people do not understand legal jargon and technical terms, so judges should keep language as simple as possible and give clear explanations. And then paragraph 23 about demonstrating fairness, which is about treating people equally in comparable situations. For example, a litigant in person with little understanding of law and procedure is not in a comparable situation to QC, so it's substantive equality that counts. And I also note paragraph 25 about language and the system, and also paragraph 28, where it points out the judges may not be able to assist a party with their case, but can ensure that they have every reasonable opportunity to present their case. And pausing there, Lord, underpinning my submission, and I should make this clear, is that, of course, what the court should do is what's reasonable. We indicated in our skeleton argument that litigants in person, like other litigants, have to comply with the rules of court. But it is a question really of what is reasonably needed to accommodate a party to allow a fair trial. And that's got to be the touchstone. If your lordship moves on to page 1070, which deals with litigants in person. And point out there, you know, the under the court's duty LIPs that litigants in person may be stressed and worried, or operating in an alien environment in what is for them effectively a foreign language. Your lordship will have picked up that Mr. Mehta is not a native English speaker. It's his third language. And so aspects of linguistic distancing and distinction are acute in this case. He's also a layman.
You talk about his language.
Yeah.
I must say, it always looks different reading from a transcript, but I had no doubt that when I heard him speak, that he was fully conversant with English and had no difficulty in both explaining himself and understanding, not always in full grammatical sentences, but understanding what was going on. And so you'll need to, I appreciate sometimes that it doesn't look the same way from a transcript, but that was my clear impression.
Well, my lord, I think we'll have to look at the transcript, but also what your lordship will have to appreciate is that there is a distinction between being able to understand in an immediate discussion, but also legal English, being able to, as we'll say, come on and present a defense in a case and sort of articulate all of these matters and absorb them in a way that would be fair at trial. And I go back here to substantive equality. And your lordship, I think the submission we make is that there has not been anything like the sort of proper accommodation that's required for a litigant in person defending a $30 million fraud claim in their third language with no legal training. That's going to be the nub of it. And if you look at points about the difficulties that are faced by litigants in person, there's a section which is mostly relevant to English courts at 1073. But your lordship has to, if your lordship looks at 1075, please. There is a point about the difficulties that are faced that stem from a lack of knowledge of procedure. And they point out in paragraph 15, the authors of the bench book, that the procedure is so familiar to lawyers and judges that they often do not realise the extent of the litigant in person's misunderstanding. They tend to be unfamiliar with the language and specialist vocabulary of legal proceedings, little knowledge of the procedures, and difficult to apply. This is plainly a classic instance where all of these points, my lord, apply. And that's why, where it says ways to help at paragraph 17, your lordship, with best practice in mind, not only had to explain so that it could be understood, but also ensure there was access to information about what was expected of them in ample time for them to prepare, and wherever possible, they were given sufficient time for their particular needs. Now, of course, that's not open-ended, my lord, but your lordship has to think, even taking into account questions of prejudice, the other side, well, what were they? Your lordship was right to say that the trial had been set down for some time, but there's a freezing order, there's a judgment for $31 million already. And then, as we'll come to see, there was a very big change of the situation on the 3rd of October. Lord, in relation then to move on to 1076, your lordship was facing not only a language but a cultural barrier. And there's particular areas of difficulty identified in relation to language at 1076. Because there is a whole section, which I'm not going to take the lordship to, but about the need for communication and the difficulties that are likely to become more acute when a person is presenting their own case without any representative to mediate cultural and linguistic understanding. And then we move to 1078 about case management, understanding directions of court orders, because that's, of course, also direct relevance when your lordship was having the discussion primarily with Mr. Reed on the 3rd of October. If you look at paragraph 29 there, my lord, there was a need to involve the litigant in person in the process for giving directions and asking how much time was needed to take a particular step and why, so that they could realise how the directions related to conduct. Although the bullet point 2 below that says, do not simply ask, do you understand? Because even if you indicate that you're happy to explain, the LIP might say yes out of embarrassment, because they're anxious to appease if there's time pressure, or because they wrongly believe they do understand, or to save face. Saving face is a universal concept, but this can be a particularly important issue for certain cultures. Now, my lord, there are various other points throughout this document about the need for assistance. There's one other point that I wanted to raise. If you look at page 1086, regarding difficulties at the hearing and how to help. And you see there, we say 62, your lordship is a facilitator of justice, may need to assist the litigant in person, attempt to elicit the extent of the LIP's understanding at the outset, make clear the concept of the just trial on the evidence, exercise considerable patience. Then at the second to last 2 bullet points there before the subhead, not engaging in a legalistic dialogue with the legal representative, which can make the LIP feel excluded and appear to be unfair. And then also there's a section on remote hearings. Now, my lord, all of those points are central backdrop to fair treatment and the perception of fair treatment, both on the 3rd of October and how it would have looked. to Mr. Mehta. There are two other points on fairness which I deal with at the skeleton argument. The first is that it is identified in the.
Where are you?
I'm looking at my skeleton argument on the set aside at paragraph 33.
Yep.
So we've talked about the rules of the DIFC court practice. We've looked at equal treatment bench book in a bit of detail. The third point is 33.3 is actually considering what was being requested. Now, he has been shown to be valid because he had funding. He has funding now. Was seeking to get time to allow proper preparation, and he asked until the beginning of 2022, and that's where we were when we filed the applications set aside and so on. And ideally, that would have meant funding preparation would have gone into preparing for trial rather than these procedural applications. But he was attempting to put himself into a position to have equality and redress the obvious imbalance, my lord. And it's well established in other contexts, I say little paragraph B, that fairness includes allowing a party to access funds to permit legal representation. I cite the Popplewell, Mr. Justice Popplewell decision in Funda Soberano. That was a different context, which was permitting funding from frozen assets. But the advantage there was identified in the quote as both to the court, but also to the defendants, because the party would be assisted and the courts would be assisted by being professionally represented, and the court accepted that in that context.
I see that, but how does that arise in the present case?
Well, so how it arises is this. He says, given what's happened, prime is settling, and as your lordship accepted in the judgment, prime was expected to lead the defence through its leading counsel and team of juniors. I'm going to have to run this whole defence. I need more time to get money, and so that my lawyers can then deal with all of this and present this so that I can have a fair trial. And he says so in terms to your lordship on the day, and we'll look at the transcript. And what I'm saying to you, my lord, is that when you're considering fairness and the fairness of a trial, and your lordship also has a point that under the European Convention on Human Rights as regards a fair trial, it applies in the sense of equality of arms and a fair opportunity to present the case. You're saying, I can't present this case from effectively taking over the burden that would have been taken by leading counsel and so on. Give me an adjournment. You've said 2 days. I can't do 2 days. Give me enough time. I can get lawyers, I can get funding, get lawyers, and then have a fair trial. And so what I'm saying is to good reason is that he didn't think he was going to have that fair trial. He couldn't have that opportunity and equality of arms because all that happened was a 2-day adjournment when, as far as he was concerned, frankly, the world was turned upside down because prime was out of the case. And your lordship, when considering fairness, when considering whether that was a fair perception from him, has to have in mind, how would this have looked to Mr. Mehta? How could he have prepared this case? Even in your lordship's throwaway comment, except earlier in the hearing, where he could have asked for a couple more days. We're not talking about a couple more days in the reality of this $31 million case, my lord. So perhaps
that was in a different context. I was putting that.
Oh well, I'm sorry. In which case,
what it seems to me. Sorry, just
yes.
I take that a party litigant should be given access to the means of instructing lawyers and so on. Mr. Mehta had been asking for an adjournment for several weeks, I think, before the hearing. And he had, on each occasion, put forward some information about the difficulties of funding, but nothing like enough to justify acceding to the application for an adjournment. You may or may not agree with that. but he would give rather vague instructions like that my third-party funder, I can't access his money without going back to, I can't now remember where it was.
He couldn't get to Singapore to get to his bank because of lockdowns, my lord.
Yeah.
Yes.
But
And
there was nothing to make that sort of thing persuasive to the court, like backup from the banks or anything of that sort.
well, my lord, 2 points on that. Firstly, his banks weren't dealing with him because they'd frozen all his accounts.
His third-party
But
bank.
I think that would have, again, I mean, I don't know what his third-party bankers said or could have said, and I appreciate your lordship dealt with those on those terms. There was a further point I should have made, is that your lordship also said that he hadn't given disclosure of his assets, so your lordship wasn't convinced he didn't have any money.
Yeah.
Well, once he did get funding, I think from early in November, he has filed an affidavit and given disclosure and purged his contempt in all of that regard. And part of, but I appreciate that wasn't clear to your lordship at the time of the adjournment.
Sorry if I can interrupt. What is a court meant to do when there is an order for disclosure of assets that hasn't been complied with at that stage? The litigant comes along saying, I can't instruct lawyers because I haven't got any assets to instruct him with. And when he hasn't complied with the court order to disclose his assets.
My lord, as soon as he got funding, he did. And I think what I appreciate what the court says, and I appreciate how it may have appeared at the time. But bluntly, my lord,
that's not in fact correct. That as soon as he got funding, he engaged with the order. He got funding for the set-aside application, which occurred before me about a year ago. He got legal representation from that, and then still didn't comply with his obligations under the freezing order.
My lord, I can't make submissions about matters that predate in those circumstances. I just don't have the facts. But your lordship was there. Your lordship was there. I wasn't.
He appeared before me to set aside the order of default judgment.
Madani, yes.
Yeah.
Judge
He
Madani,
set
yes.
aside default judgment. He is represented by counsel, and that was well after the worldwide freezing order and the obligation to disclose his assets. So he had lawyers at that stage, and he accepts he had lawyers.
He did, my lord. I've seen a name of some counsel, and obviously your lordship made a judgment.
There were also
that led to fraud.
solicitors called AW. I can't remember what they.
There might have been the Indian firm, AMA, my lord. I've seen
AMA,
documents.
Yeah.
Yes.
Tell me, what is the court to do when the application is made for an adjournment to instruct lawyers on the basis that you can't access funds when there's been no disclosure in accordance with law?
My lord, what your lordship has to do is consider how much time is properly needed to allow this individual who's appearing in person, who doesn't speak English as his first or second language, is not a lawyer, has not complied, as far as the court's concerned, with certain disclosure requirements, but at the same time is facing a very serious consequence and a very serious trial with long-reaching potential effect. How do I give an adjournment? If I'm giving an adjournment, what sort of adjournment should that be properly in consultation with this defendant if he's going to be appearing in person, to allow him either?
I think, Mr. Pillai, you're eliding 2 points. There was the general application for an adjournment for legal representation, which had been going on for,
Yes.
if I say weeks, it may be a month or two. I don't remember exactly. Which I dealt with in repeated rulings. Then there was a second question, which only arose on the first morning of the trial, about the difficulty Mr. Mehta would face with the withdrawal from the action of Prime.
Lord, yes.
And the 2 days I spent, or 2 or 3 days, whatever it was, suggested then was to allow the case to be reformulated so that he knew what was against him. Now, there was nothing in that context that prevented him coming back in 2 days' time and saying, well, now I've seen it, I need more time because there's a new situation. In fact, it was me that raised the question of adjourning at all for the purpose of taking account of the time position, not Mr. Mehta, I think.
No, well, my lord, I think we're going to have to look at the transcript, because actually the adjournment you gave was essentially the adjournment that Mr. Reid asked for.
Oh, okay. Whether it's Reid or me, it wasn't Mr. Mehta saying this has changed everything.
No, well, I think we should come to it, my lord. But Mr. Mehta asked for much longer in order to deal with it. And your lordship, you're right. There was a lot of adjournment applications flying around. I think there was one that had predated the 3rd of October, and then Prime settled, and he asked for another adjournment, effectively on his feet, as it were, before your lordship. And that's where he said, give me 3 months to do this, to find funding. Your lordship gave 2 days, and I think he then put in another paper application. But as he says in his evidence, it seemed futile because the judge, I wasn't going to have enough time. And your lordship's right that it would have been better if he'd come and said, I've looked at it and I can't possibly do it. But also your lordship has to take into account that you're dealing with a litigant in person who effectively had been given this, it's happening in 2 days. And after 1 day of which he was served with a new skeleton argument. Now, your lordship, appreciate, I'm not asking your lordship to have bent over backwards and given in to everything that was asked for, but by the same token, in my submission, there was much more empathy required and consideration from what the actual burden was. And there's the other point is that I'm not trying to rerun an adjournment application for your lordship. All I have to do is show that there was a good reason for non-attendance that meets the not very rigorous standard as to conduct. And so, well, can I then move, because it is 10:15, to because we've got to get to the transcript on this. There are 5 questions on this. The first is whether they attended the trial. Secondly, whether they acted promptly in applying the set aside. Thirdly, whether there's a good reason. Fourth, there's a real prospect of success. And then fifthly, if those 3 requirements of the rule are met, will the court set aside the order?
Yeah.
Okay, so that's the structure. First, on attendance at trial, I'm surprised that your lordship says that there was attendance at trial, and the word trial is not defined in the rule. And essentially, the point is about when the trial started. The trial plainly only started, in my submission, on the 6th of October, and he didn't attend it. If your lordship, I mean, the judgment itself at the very first page says that the first and second defendants did not appear and were not represented at the trial. Secondly, in your judgment at paragraph 21, your lordship said that the judgment, that inquiries from the registry confirmed Mr. Mehta did not intend to appear at or take part in the trial. And the last sentence of that paragraph says, accordingly, the trial proceeded in the absence of Mr. Renish and Mr. Mehta.
Paragraph what?
Sorry?
What paragraph was that?
21.
Yep.
So therefore, my submission is plain from the judgment that it proceeded on the basis he hadn't attended. And that's also the basis on which SBM was proceeding. Your lordship has access to the transcripts. They're, I think, in a bundle called ZZ.
Mm-hmm.
If you look at day 2.
Hang on.
Oh, no, sorry, ZZG. I'm so sorry, my lord. Now, I'm going to look at ZZG. 75 is the beginning of day 2, and then look at page 78.
Yeah.
And your lordship, at the top of page 70, ZZG 78, there's a discussion, if you scroll up, about dealing with the adjournment applications.
Yeah.
And then at ZZG 78, at line 1 onwards, at the end of 1, Mr. Reid says, in order that it be clear that the first and second defendants are failing to attend the trial, I think we have to dispose of the application. So there he's plainly saying that, look, they're not attending the trial. And then if you look at the foot of ZZG 82, there's at about line 15, 2/3 down, your lordship asks Mr. Reid, where do you want to go from here? And then Mr. Reid says, look at RDC 3514. This is the day 1 of the adjourned trial, and we're in a situation where defendants fail to attend trial, and therefore the court goes on the next page, may proceed with the trial in the absence of a party. Then he said, well, I'm not going to ask you to strike out or prove my case. And then there's actual contemplation, therefore, of what you do when a party has not attended trial. And then also, well, we say plain that the trial didn't start until the 6th of October. Firstly, SBM served another skeleton after the 3rd of October, so one can't see how the trial started on the 3rd of October. And then and opening submissions on the trial began on this day, so on the 6th of October. So he came to the hearing on the 3rd of October, but the trial is not necessarily within the concept of a hearing. We've got that in the procedure in the CPR, if your lordship wants to look at that, and it may be sensible to do that, given your lordship had a very strong view on this point when we were starting out on this.
I didn't. I just said I need some persuading.
Okay. Well, my lord, there is essentially the word hearing includes a trial, but trial doesn't necessarily include a hearing.
Yeah.
If you've got, it's in ZZK, the notes in the white book, ZZK 350, 351. But we say really it's plain that the trial was what began on the 6th of October, and Mr. Mehta didn't attend it. And in the context, it all has to be construed in context, because the rule doesn't define what a trial is anyway. So your lordship can do that afresh. But how it proceeded was plainly on the basis that the trial started on the 6th.
Right.
Well, so that's my submission on the first point. Then on the second point, we say that we acted promptly. The timing point is that one has to act from the moment that they found out the court had acted on the power, i.e., and the first time was when the order was made. And we deal with that. Your lordship has the skeleton. It's at paragraph 25 of the set-aside skeleton onwards. Maybe that's the easiest way to take my submissions on this.
Sorry, paragraph what?
Paragraph 25, which is page 11.
Yep.
So the wording of the rule, just to remind, is that the party must have acted promptly when he found out that the court had exercised its power to strike out or to enter judgment. That's 35.18(1).
Yeah.
So the court exercised its power to enter judgment by making its judgment on the 29th of December, 2021. So that's when time runs from.
Yeah.
Your Lordship sees that from the rule, found
Yeah.
out that the court had exercised its power to enter judgment or make an order against him. So your Lordship's exercise of the power was when your Lordship made the order on the 29th of December.
Sorry, I'm being rather slow. Okay, carry on.
35.18(1).
Yeah, I've got it.
Yeah.
Well, don't worry.
No, Lord, tell me. I'm here to help.
Thank you. What I was wondering was whether that actually contemplated a case where the matter proceeded to trial, or whether it was dealing with the administrative act of striking out, entering judgment, or making some other default order. But I think you're probably right, it applies equally when there's been a trial. Yeah.
Well,
okay.
a default order is not dealt with by 30. I mean, this is failure to attend trial, so it's not setting aside a default judgment. So I think we're squarely in the current territory.
The failure to attend trial
Yeah.
is covered also, though, by striking out and giving judgment and so on. And I wasn't sure whether it also covered the situation of simply proceeding in the absence of the party. But I'll assume it does for the moment, unless I'm persuaded otherwise. Anyway, carry on.
Okay, my Lord. So we say time runs from the 29th of December, and what happened was the applications were filed on the 21st of January.
Yeah.
The judgment landed in that holiday period, but as what's said at paragraph 26, Mr. Mehta managed to get funding to get advice on this judgment and order, and obviously the appellants, the appeal had to be prepared at the same time, but in any event, that was done promptly, we say in any view, to get that in. We say the defendant's points also don't assist them. It suggested that Mr. Mehta should have realised that he would lose the trial and so should have been preparing from the October 2021. That just misunderstands the language of the test. But it also seems to be a concession that SBM knew that if the trial went ahead, on that adjournment, Mr. Mehta, should have understood he was going to lose. It's suggested that the defendant knew how to make a set-aside application. Well, knowing what the law is or the procedure is doesn't take you further, because any application must be made on its own facts, as this one has been. Thirdly, there's a suggestion that there was a tactical delay to file the appeal at the same time as the application. I mean, we say again that's misconceived and it's wrong. There's a court deadline for the filing of the appeal. What had to happen at very short order, because the instructions following the funding only came in fact on the 11th of January, was that everything was done expeditiously and as quickly as it could be, and the court's deadlines have been met. So we say that there's no tactics, and it's not clear what the tactic is in any event. The facts all demonstrate that this was done promptly.
Yeah.
Then, my Lord, we move to the third limb, which was good reason. And we've really touched on that already. I'm just going to make some key points in no particular order, and then we're going to have to look at the transcript. I'm conscious that time is running. First, Mr. Mehta is not a lawyer, inherently unfamiliar with the rules and legal jargon and so on. And he deals with all of this in paragraph 27 of his witness statement, Meta 8. You have the cross-references in the skeleton. His own evidence is that he did not understand the instruction that was given when he was asked to fillet Prime's evidence and present it. The preparation that would have had to been carried out, my lord, to prepare an opening, ask questions of witnesses, that was something he was intending to do plainly in the context of Prime as leading. But actually the new task when Prime settled was having to run the entire defence single-handedly. Now, in an ideal world, that's tough on counsel, but you're asking for an opening, cross-examining factual and legal witnesses, and doing a closing. A side note, as we understand it, the DIFC court only allows advocates with 5 years experience to conduct trials. So we say that asking a litigant in person to do that in a foreign language and remotely on a 2-day turnaround is a significant ask. We've talked about the language barriers. He also had problems accessing case lines, and that was also clear to the court on the day. He'd contacted the registry for help, but he also explained this to the court. And we say the pausing on that, that's what required special recognition by the court to try and establish a level playing field. And the consequence of Prime settlement was that it really laid this all on to a man who had no training and real time to prepare on a complex matter with serious consequences. So if we look at the transcript, that's at, well, we were looking at it, ZZG, wasn't it? And day one.
Mm-hmm.
And so, my lord, it begins with the usual administrative discussions, and then discussions with Mr. Pluman and Mr. Reed about the settlement. And at about page 12, your lordship, do you have that ZZG 12?
Yeah.
Your lordship, halfway through, speaks to Mr. Mehta and explains that there's been a settlement. And at the bottom of the page, you say none of that affects the claim against you. Do you understand? And then you ask whether he's understood, if he wants to say something. And then he starts talking at about ZZG 13, line 7 onwards, effectively running various merits arguments about the importance of Prime and his applications to adjourn and how he's lost his solicitors. And so therefore you have to stop him. And then he's plainly trying to process what happens in relation to Prime and continues to deal with that at 13 to 19. Now, your lordship asked if he'd understood what had happened, and I think proceeded on the basis that he had understood. You just go to ZZG 68, which is towards the end of the hearing.
68.
Yeah. So plenty of water under the bridge by then. But if you look at this, you had been discussing directions with him. But you look at ZZG 68, line 6. He asks you again, are you releasing Prime energy, or how is it? And then if you look, my lord, at 70, the foot of the page, line 20, he asks you again. And you go on the page. And your lordship, I appreciate, is valiantly trying to explain to him. You're asking him to tell you what evidence saying, you know, just go and identify what evidence you want to rely on. But he's still saying, are they released? You can't let Dentons do last-minute surprises and so on and so forth. And my lord, I raise this because it seems clear that throughout this hearing, he's processing that, and he hasn't really understood exactly why it's happening and why it's okay. Now, my lord, can we move back to 16? I appreciate the reality of this, my lord, is that we're going to jump around this transcript a bit, and your lordship will want to look at it in your lordship's own time, I'm afraid.
What page?
So I was going to go back to 16, which is then dealing with once Mr. Pleedman leaves. And as I say, I don't think we need to turn up, but if you want it, your lordship accepted in the judgment that the consequences of the settlement were that Prime, which was represented by counsel, would have clearly played an active role at the trial, probably the lead role in defending the claims.
Yeah.
So then at page 6, ZZG 16, at line 10, your lordship asked Mr. Reed, where do we go? And Mr. Reed then starts by saying, well, look, it's changed, you know, can we ask for some time? And then there is quite a long technical discussion. Your lordship asks at page 17, you know, why are you doing this? You have a money judgment against Mr. Mehta. There's a discussion that's back and forth. And I've touched on why we say the answer doesn't seem to go anywhere.
I think in line 10 on page 18, when I say it's an important point, I think I probably said it's an enforcement point.
Oh, I see. Well,
that would make more sense in the context.
My lord, I see that, yes. But again, it's not clear why.
It doesn't matter.
Yeah, well, it's not clear why having a fraud judgment would be an enforcement point.
No, but it's what I'd been.
It's probably what you would have said. I appreciate that.
Yeah.
But my lord, it goes on ZZG 19, a paragraph at line 18. Having had a discussion about timing, Mr. Reed says our preference would be to postpone opening if your lordship minded agree until Tuesday morning. Now, again, that also goes to my point about trial not beginning on the 3rd, but only beginning, you know, when the parties reconvened. And then there's further discussion about timings. And my lord, these are of the nature of technical discussions between counsel and a judge, of course, some of which are necessary, but which are being conducted without real input, which is why at the bottom of ZZG 20 is the first time Mr. Mehta pops up and says, could I say something? And then, but your lordship is understandably making a note and then carries on discussing with Mr. Reed. And then this begins, as I say, a point that we talked about on the relevance, but this is, your lordship talks about there's a question about witness statements, about what he'd been able to rely on as hearsay. And then your lordship so deals with that at lines 6 to 10. I can ask Mr. Mehta about what he's going to do about hearsay. And then on the next page, about 5 to 16, your lordship points out that there would be bits of statements Mr. Mehta might want to rely upon, and then also bits in prime skeleton argument. Your lordship sees that.
Yeah.
And it's important, my lord, because what this points out is that your lordship is well alive to this, as was SBM, as to the importance of this material being presented in support of Mr. Mehta's case. Now, the mere fact then that Mr. Mehta didn't appear at trial doesn't mean it wasn't still important, shouldn't have been raised. In fact, it should have been raised. And it was at the forefront of the discussions, and goes back to what we had talked about on the duty of fair presentation. This is not stuff that is arcane or had to be cherry picked from the deep recesses of the bundles. This is forefront material your lordship thought was going to be relevant and then was not raised.
Mm-hmm.
And my lord, the approach that was taken was essentially from SBM to put the boot in and keep stamping. That plainly isn't what's required to comply with the duty of fair presentation in these circumstances. But my lord, in relation to, if your lordship may have been scrolling on, your lordship was thinking about the mechanics of this, but again in a very technical way, and I understand why that was done, but that's not really what, because your lordship's talking about hearsay evidence, which isn't explained to Mr. Mehta. Though you do go on to deal with this, I'm certainly not being unfair to your lordship, but you're talking to Mr. Reed about what's required, and you say it must be the case, if you look at page 23, that he must be able to adopt paragraphs 50 to 70 and so on and so forth. And my lord, that actually is the answer to what you were saying about it. Well, it's not in the case. But what should have happened was it should have been said to your lordship, this isn't an evidence, but it does go to weaken or undermine SBM's claim. Here is the point. Your lordship proceed on the basis as if the defendant was here and that it had been adopted by him, or otherwise that he had made a hearsay application and it had been accepted. But then, my lord, if you see, then your lordship then first turns to Mr. Mehta at 23. At the bottom of page 20, it says ZG23. So have you been following? And then your lordship doesn't have an answer from him. I think, but what your lordship does is explain what's just been agreed. And your lordship sees that your lordship has adopted Mr. Reed's suggestion at time, and then reordering the case, and then you cross-examine. And this is highly technical with respect to your lordship. And it's at the end of it, your lordship just says at page 25, line 8, "Do you understand me?" And then Mr. Mehta says, "Yes, sir." And then you say, "Are you content with that timetable?" And he says, "I want to say something." Now, so my lord, pausing there, I'm afraid that we're falling into all of the problems that, as to a lack of empathy, as lack of understanding and where he's going on this. And he explains in his evidence, my lord, that he didn't understand what you were asking him. And then when he says, "I want to say something," he starts talking not about the timetable. You look at ZZG25, line 15, but he starts explaining his concerns about prime. Now, you're right, my lord, he explains this articulately, but he's not talking about practicalities. He's talking about, they've gone.
Sorry. I had to stop the dog scratching at the door.
Understood. He's talking about practicalities, my lord, and his concern about these parties not being in there. And as he says at line 24, "Our main concern is, sir, I don't have any defense counsel. It's really," and goes on, "really very difficult for me to rejoin the case within such a short period." So that is addressing the 2 days, and give my explanation and all this. So my request is please give us some reasonable, so vacate current trial and give us a reasonable time. I'm reading from the top of page G26. So by the time we should be able to find our defense lawyer, take legal advice. That is our request. It should be somewhere in the beginning of next year. So once they will all make all the fresh submissions, so it will be good for us. So he's understood parts of what's happening, but he's plainly not understood what's being said about evidence and so on. And what your lordship then goes on to say is, well, look, the paraphrase, beginning at 14, but it's essentially the case against you is the same. You'll have time in light of the timetable that's been suggested. Now, the timetable that's been suggested was really for SBM's counsel to put in a new skeleton. And then your lordship goes on in a rather sort of technical discussion again about there'll be parts you agree with, disagree with, talk about cross-examination. And my lord, essentially, the idea that the case had not changed, that there'd be time to respond in the timetable is unrealistic, because firstly, Prime wasn't there. Secondly, there was going to be a new skeleton argument. So your lordship has to bear in mind, if a litigant in person doesn't speak English, isn't a lawyer, gets a new skeleton argument, even if it's revised, given that your lordship himself said that SBM's skeleton argument was difficult to follow, the original one, what is this individual going to do to prepare his whole defence within 2 days? Now, my lord, your lordship did give further explanations at page 28, line 16, but you were talking about the difficulty of cross-examining Mr. Sada and Mr. Farhang, and said one way around would be for you to identify in advance those parts of their evidence you want to rely on because you say it's favourable to you. My lord, if you see that, and it goes on to page 20. But you're talking at cross purposes, because you're saying, please, can you tell me which bits you want to rely on? And then Mr. Mehta still going on about the point that's his preoccupation at 29 lines 9 onwards. He said, yes. So again, your lordship is seeing agreement when it's not really agreement, because he says, let them file their documents. We should prepare our trial. Any other trial date by beginning of year would be great for us. And then your lordship says at line 20, I'll give you every opportunity to adjust your case to the new circumstances. But your lordship gave 2 days. And on the next page, there's more from Mr. Mehta saying, just give us enough time to get lawyers and we can prepare reasonably. I'm not asking for you to adjourn, but of course he was asking for you to adjourn. And we say that none of these discussions in any event, my lord, reflect a pause either from you or from SBM saying, well, what's this man going to have to do? And really allowing a 2-day extension was actually something that would have been okay for lawyers to turn this round in. And he explained at page 32 at the top of it, line 1. Your lordship again is talking about details about trial timetable, the opportunity of seeing the material, and he says, I'm not aware of law and custom and practice and all this. So 2 days for people like me who really have no knowledge about laws is really impossible, sir. So, my lord, that really is setting out the position. He explains towards the end about case lines, and you've got the references in the skeleton argument. Let me see if I can find it quickly since we're on the document. But your lordship took the time to started trying to take the time to see if he could deal with the document, and it was plain that he hadn't used it. If you look at page 58, bottom of 57, my lord, GG 57, so ZZG 57.
Yeah, give me a second. Yeah.
So you asked him at line 23, Mr. Mehta, do you have access to the court management system? What is that, sir? It is not a promising start, my lord. And then your lordship goes on the next page, case lines. And then your lordship rightly wants to test it. You propose a test at page 6, line 6. And your lordship was told, really, I have no good knowledge of computers. I'm taking help. I will learn it, your lordship. And then he goes on again to say, I've got a good case, but I just need time. Now, so your lordship there, pretty clear that he plainly hasn't used case lines, didn't do a test.
Hang on a second. I tried to get him to go to one particular page just to test it.
My lord, you did. You did.
And he then said it won't be an issue. I'll do that.
Well, my lord, the question really...
You're saying the technology wasn't a problem.
Well, my lord, your lordship didn't test it. And it must have been apparent that as at that time, it looks like he hadn't really used it. He had emailed, as he'd put in his evidence, to ask for support from the registry, which supports his account in that regard. My lord, all of this we say, and I've got to move on, but goes on to the point that the question for the court is whether this all supported a good reason for not attending. We say that actually, had the court properly had in mind the type of points set out in the equal treatment bench book, and also the aspects of fairness, which I have cited about fairness of being able to present your defence at trial, but it should have taken a different decision in relation to adjournments. But we're not talking about deciding on adjournments. The question is whether this all supported a good reason for not attending. Your lordship, please must read the evidence of Mr. Mehta in this regard, explaining how it looked and why it wasn't essentially fair, and how it appeared to him that he wasn't going to be able to defend fairly. I do note, my lord, I'm sure SBM can tell us otherwise, but it appears that the claimants sent a lengthy letter trying to explain how to use case lines to Mr. Mehta the day after the 3rd of October. So they plainly apprehended there was an issue in this regard. We say that the cases are clear. The court should not be very rigorous. The test is more generous, and he couldn't have marshalled the arguments. And in those circumstances, without justifiable state of mind, he didn't attend. We say on the circumstances of this case, which are exceptional and rare, that constitutes a good reason. My lord, the fourth point is whether there's a real prospect of success, and we've already talked about that at length. I'm not going to repeat that. So then the fifth question is whether the court should exercise its discretion. We say that all of the hurdles are met. The court should set aside. It would only refuse to do so in an exceptional case. That's what Lord Neuberger said in Pereira. My lord, there isn't a basis in this case for concern about floodgates or rules being abused by rogue litigants, because the facts of this case are very rare. Consequences are very serious. Principles are well established in common law and should be applied here to set aside the judgment. So, my lord, that, and I know that we've had quite a back and forth on this, that's the set aside application. On the permission to appeal, I don't need to address your lordship on the test, and we've really talked about all of the grounds at various points. The tests we say are met, and can I just run through some of the points against on each of the grounds, or I can save that for response? Or,
No, carry on.
Lord, on the first ground, if you've got the permission to appeal skeleton, that's probably the best.
Right, give me a second.
Yes.
I think this is it.
It's a February document, my lord.
I know. But they look almost identical. That's the problem. Okay.
My learned junior would be keen to point out that this is in Palatino linotype, as opposed to Times New Roman for the other one.
Right. Well, italics or something would have been helpful. Yeah, okay.
My lord, ground one is at paragraph 51, and I'm just going to summarize it. It's essentially saying that your lordship wasn't provided with the correct test on the standard of proof. We say that that point is well made because your lordship wasn't invited to consider the inherent probabilities. There's no debate that there's one civil standard of proof, but your lordship wasn't presented properly with that, and also should have been directed to a finding in the CMOC case about an inference of fraud should only be drawn where it's the only reasonable inference to be drawn. Now, what's said by my learned friends is that that's sort of not the correct legal test. They rely on two cases called Keckman and Sofa that are strikeout cases in relation to pleading points. Neither of those cases refers to CMOC or to the Mr. Justice Tier's decision in JSC and Abliasov, which we rely on. It's at paragraph 55.3 of the skeleton. And we say that what we've set out is correct, or in any event, there's a real prospect of success in this regard. Your lordship has to be very sure in this. There are different tests for striking out and different tests that the court should have been taken to based on CMOC. It's also suggested by my learned friends that the appellate courts can't interfere with findings of fact. We deal with that, my lord, in the PTA and ground skeleton. There were very limited findings of fact, and there was no live evidence and limited documentary evidence. So the Court of Appeal would not be disadvantaged and is in just as good a position as the judge in the first instance court to interpret the evidence. That's established by the Court of Appeal in Stilianu. If your lordship had heard 5 days of evidence and cross-examining, then that would be a different position. But this is a case where the appellate court could review the points, and the high bar, insofar as it's suggested there is one on the factual points, is met here, because we say that your lordship's conclusion on the finding of facts was inconsistent, given your lordship's findings effectively dismissing the majority of the alleged fraud claim. Your lordship hadn't, and this goes into ground two, in fact, hadn't been given the correct test for dealing with the actionable representations. My lord, ground two is at paragraph 62 of the skeleton in front of your lordship. And we've covered this in some detail, so I just wanted your lordship to have eyes on it, as it were, is that you were not taken to and therefore couldn't identify and apply the correct test on whether there's an actionable misrepresentation. Corinth, we looked at and is no answer on this.
Yeah.
My lord, ground three is at paragraph 75. And that again we have touched again, so that the summary point is that your lordship erred by holding that there was liability in respect of two misrepresentations on the fifth and sixth payments. We say that that was not supported in the circumstances, was inconsistent with your lordship's other findings. And then ground four again, which is that's a paragraph 85, my lord. And that's the one about the fact that the duty of fair representation was not complied with, means that the trial was not fairly run. My Lord, I've covered all of this in quite a lot of ground. I'm really grateful to your Lordship for his patience and indulgence. Is there anything else I can assist you with?
No, if there's anything that arises unexpectedly from the other side, I'll come back to you. But that's very helpful. Thank you very much.
Grateful, my Lord. My Lord, I'm going to turn off my camera. No disrespect intended. But
Well, what I'm going to do now is I think we should have a break of half an hour. And Mr. Wheel, are you happy with that?
Absolutely. I was going to offer a shorter break, and I'll have no difficulty in completing my submission.
Let's have half an hour, and I'll try and make sure that I can actually see people when we resume.
Could I just mention this before we break? It would be helpful if your Lordship were to have to hand as separate documents my learned friend's 2 skeleton arguments.
Yeah.
Because I'll be referring to those.
And yours, presumably.
And mine as well. Yes, please.
Yeah. Very well. I'm going to disconnect and try and open again in a few minutes' time. But we'll resume at 11:30 UK time.
Thank you, my lord.
Thank you. Right. If everyone's ready, I'm ready.
Grateful. Well, my lord, consistent with the approach in Pereira, I propose to take the applications in order, dealing with the set-aside first, and then making a few brief observations on the permission to appeal application. So turning then to the set-aside application, in my respectful submission, it is a hopeless application. Not only do each of the 3 cumulative limbs, not only have they not been satisfied, but the application doesn't even get off the ground because the relevant provisions aren't engaged. What in fact happened in this case was that the defendants turned up on the first day of trial. They saw which way the wind was blowing, they didn't like it, and then they made a deliberate decision not to participate in the remainder of the trial. Now, my learned friend has made a valiant attempt to try and argue that the first day of trial was not part of the trial, but in my respectful submission, that is plainly wrong, and it can be shown to be wrong by reference to the orders that have been made in this case. And in particular, I invite your attention to C76, if you're able to turn that up. And
C76.
C76, this is the order of Justice Ali Madani, and the relevant paragraph is.
I'm sorry, all my documents are ZZs.
Oh, okay. Sorry, this was a reference to the trial. Well, it doesn't matter. Let me just tell your lordship. This was the directions order of Justice Ali Al Madani, dated the 28th of February 2021. Paragraph 14 of that order directed as follows: the trial of this matter is subject to the availability of the court, listed to take place on the 3rd of October, with an estimated duration of 7 days. So that puts beyond doubt that the 3rd of October was indeed the first day of trial, and indeed it couldn't be anything else. The fact that your lordship adjourned the trial partway through does not detract from the fact that the 3rd of October was the first day of it. So with that in mind, please could you turn to the Blue Book at page 475.
Yeah.
And as you can see from the heading above 35.14, this suite of provisions is premised on a failure to attend the trial.
Yeah.
And there are essentially, as your lordship has already identified, 2 parts to this section of the rules. The first part at 35.14 confers powers on the court, which are only engaged if and insofar as a defendant or claimant fails to attend trial. And as you'll see from the subparagraphs there, the court is empowered, when it wouldn't otherwise be, to strike out the claim or the defence. But the court's power is only engaged if the relevant party doesn't in fact turn up. Now, the remainder of the rules are essentially the other side of the coin. And you can see 35.16 or other and following, that where a court makes one of those orders the party can apply to set it aside. And equally, as your lordship identified, even if the court doesn't make an order striking out the defence, a defendant can nevertheless apply to set aside the order that the court does make. But the crucial point is that the trigger for all of these provisions is a failure to attend trial. Now, if one goes back to 35.14 and asks the question, could the court have properly proceeded on the basis that Mr. Mehta had failed to attend the trial and struck his defence out? In my submission, the answer to that is plainly not. He had turned up armed with a skeleton argument, and he had made oral submissions based on that skeleton argument, which he invited the court to take into account. And it would therefore have been quite wrong for the court to have said, notwithstanding that, I'm simply going to strike out your defence. And the reason why it would have been wrong is because this is not a situation in which Mr. Mehta failed to attend trial. Rather, having attended trial, he decided not to participate in it after day one. Now, it's helpful at this stage to have a quick look at Mr. Mehta's skeleton argument, because it will be relevant to a number of submissions I make. But for present purposes, the reason I'm referring to it is because it shows that Mr. Mehta turned up and engaged with the trial on the first day. Now, you'll find a copy of his skeleton at ZZG 54.
Oh, this is the skeleton for the combined one.
I'm sorry, this is Mr. Mehta's and Renish's trial skeleton argument.
Right, where do I find that?
ZZG 54. Oh, I'm sorry. In fact, I'm not sure your lordship has this document. This is in the trial bundle. Yeah, but my lord, if you're using case lines, do you have access to the underlying trial bundle? So on the left-hand side of the screen.
Right, I've got to get out of this then. Hang on a second. Right, where will I find? So I go back. I get out of the E bundle for this hearing.
Yes.
That's dangerous.
Yes, my lord, there should be a master bundle, which I think will have the whole sweep of documents.
Yes, but okay. I've got the trial bundle. Is that what you want?
That's exact. That is what I want. Yes, please. So if you look at A of the trial bundle, you'll see skeleton arguments.
Hang on. Right.
And tab 9 of that, you'll find Mr. Mehta and Renish's skeleton argument, which is at A113.
Yeah.
And you'll see it runs to 29 pages. There's just a few bits I'd like to draw to your lordship's attention in that document. The first is if you scroll down to A119.
Yeah.
At paragraph 17, you'll see that there's reference to DIFC case law. So the inference I invite the court to draw is either that Mr. Mehta was being assisted by a qualified lawyer, or he was himself able to research and identify relevant DIFC case law. Then of particular importance in the context of the submissions that you've heard from my learned friend, I invite you to look at paragraph 32. Does your lordship have that?
Yeah.
So it's said that Mr. Sadder has blatantly lied multiple times. His contempt of court on multiple occasions should be seriously condemned. We want to request the Honourable Court to consider all of the witness statement and any claims by Mr. Sadder null and void. This was the trial skeleton argument that he was relying on day one of trial. And to similar effect, in relation to Prime's expert evidence, I invite you to look at what's said in paragraph 41. Said there that the report from Mazars, that's Prime's expert, is filled with contradictions and wrong assumptions. It appears as a paid expert opinion only to support baseless evidence made by Prime. We criticise the report in the harshest terms. So, my lord, it's in those circumstances that the defendants criticise us and indeed say that we were bound to commend the Mazars report and Mr. Sadder's evidence to your lordship as supportive of the defendant's case. Now, in fairness to Mr. Pillai, I assume he hadn't read those passages of the skeleton argument that I've just referred to, but in light of those passages, in my respectful submission, his argument is simply unsustainable. And in oral submissions, Mr. Mehta made clear that he wanted to cross-examine Mr. Sadder. So this is miles away from him wanting to embrace his evidence or any aspect of it. He was inviting the court to reject it unequivocally. Just before we leave the trial skeleton argument, it may be worth looking right at the end of it, because you can see a summary of Mr. Mehta's case. That's at A141, and there's a heading Conclusions.
Yeah.
And as you can see from that, and consistently with what I've just shown your lordship, the main attack in the conclusions was against Prime. And insofar as points were made against SBM, they are points that are not pursued in the proposed appeal. So one can see at paragraph 80 that it suggested that the finance that SBM provided is illegal. My learned friend doesn't take that point on this appeal. Paragraph 81, it sought to suggest that the personal guarantee is null and void. Again, there's no suggestion that there's any merit to that argument. 82, a suggestion that the worldwide freezing order be, as he puts it, vacated, i.e. discharged. That's not pursued. Repeats that the Mazars report, as well as Mr. Lavin's report, should be dismissed. And then what is said in relation to the claims pursued by SBM against him at 84 is a bare assertion that the allegations of fraud are baseless and without evidence. So, taking stock of where we've got to, my lord, the position was that the defendants turned up to trial with a detailed skeleton argument that set out their case in full. And in oral submissions, we don't need to turn to the transcript, but reference was made to the skeleton argument by Mr. Mehta on day one. So in my submission, it would have been impossible for the court to strike out the defence on the basis that Mr. Mehta turned up at trial. And for the same reason, the remainder of RDC Part 35 is simply not engaged, with the consequence that the application doesn't get off the ground. If I were wrong, the logical consequence would be that a defendant could sit through 90% of a trial, listen to all of the evidence, see that the evidence was going badly for it, and then on the last day decided not to turn up, and then say to the court, oh, well, I wasn't attending in trial, and therefore I can apply to set aside as well as to appeal the consequent judgment. That's plainly not what the draftsman of these provisions contemplated. So, my Lord, unless I can assist you further on that preliminary point, I'll deal with the three cumulative limbs that the defendants have to satisfy. And I'll take them in a slightly different order because in my submission, the most straightforward answer to the application is that there was no good reason for failing to attend the trial, if that is indeed what has happened. In relation to what is meant by a good reason, there is some guidance on that in the English White Book. And I just can give you the reference for present purposes. It's at ZZ.
Don't give me a reference if I can't find it, because I don't have a white book here.
Let's turn it up then, if we can. It's at ZZK 382.
Right. Got to go back into that bundle now. Hang on. Have I finished with the trial bundle?
Yes, my lord. Certainly for the time being.
For the time being.
Hopefully for good.
Right. ZZ what?
ZZK 382. I think it's tab 13 if you're working from tabs.
Yeah.
And right at the so this is an extract from the English White Book, and you'll see at the bottom that the heading is "Had a good reason for not attending trial." Now, I said there's guidance. The guidance is essentially confirming that there isn't guidance, but the reason for that, as you'll see from line 4, is that the ordinary English meaning of the phrase "good reason" is a sufficiently clear expression of the standard of acceptability to be supplied. But what you do get from the case law, my lord, is that essentially the cases where set-aside applications have succeeded fall into two categories. The first is where the defendant has well-founded ignorance that a hearing was to take place. And that may be because a notice was never served or never received, or because they didn't understand the notice when it was received. So that's one category of case. The second category of case is where a defendant doesn't attend because of a good medical reason. And of course, the court will expect proper evidence to support such a reason. Now, the present case falls into neither category. Of course, the defendants can't say that they were unaware of the hearing or the trial because they turned up to it. And equally, there's no suggestion that the defendants or Mr. Mehta had any medical reason that would pass muster with the court. Of course, he was stressed, as any litigant would be, but certainly nothing that disabled him from attending trial. So against that background, one needs to look at what the defendants say in their skeleton argument as the good reason for not attending trial, and invite your lordship to look at paragraph 3.2.
Hang on. Of which skeleton?
The 30-page one rather than the 50-page one, the more recent one.
Doesn't help me at where I'm on the page.
And it's on page 2.
Yeah, okay, hang on a second. Yep, page 2.
So the position on good reason is summarised at paragraph 3.2, and what is said is that his good reason for not attending was because he did not have a fair opportunity to defend himself at trial against complex and serious allegations. But in my submission, that is a wholly inappropriate submission for the defendants to make. It's for the court, not for Mr. Mehta, to decide whether or not a fair opportunity was afforded to him to defend himself. In fact, the court considered the matter carefully, and it concluded that it was satisfied that Mr. Mehta was able properly to participate in trial and to defend himself. And it's really important to note that your decision not to adjourn the trial has not been appealed. That was an order or a decision that you made on the 3rd of October. No appeal against that decision has been taken. And in my submission, it is therefore wrong for Mr. Mehta to seek to go behind that order and that decision under the guise of a good reason for not attending trial. The fact that Mr. Mehta now says he disagrees with the court's conclusion on the 3rd of October doesn't mean that he can ignore it, and it certainly doesn't constitute a good reason for failing to turn up to the rest of the trial. Even if one were to take Mr. Mehta's position at its highest, it amounts to a reason why he didn't feel able to participate in the remainder of the trial, not a reason why he could not attend trial. While you've got the skeleton open, please could you turn to paragraph 34, where the reasons for not turning up are developed. Now, I'm not going to go through each point blow by blow. I can deal with them all together. And what I say about paragraph 34 and following is that they're entirely irrelevant. At best, what they amount to are matters that establish that Mr. Mehta subjectively believed that he would have difficulty participating in trial. To which the answer is, so what? That is irrelevant. What matters is whether objectively there was a good reason for him failing to attend at all. One point I did just want to mention, because your lordship picked up on it, was the alleged difficulties in a language barrier. Well, as your lordship's already identified, Mr. Mehta spoke entirely coherently and fluently and had no difficulty whatsoever understanding what was said in the course of oral exchanges on the 3rd of October. And added to that, he has submitted detailed witness statements in these proceedings in fluent English, with no suggestion in those witness statements that he had any assistance or indeed in any difficulty in understanding, writing or reading English. Just for completeness, it's perhaps worth taking your lordship to Mr. Mehta's evidence in support of the set-aside application, just so your lordship can be satisfied that the evidence he's put forward doesn't take matters any further either. And you'll see that at ZZB 5.
Nearly. ZZB3.
ZZB 5. Tab 3. It's his 8th witness statement.
Tab 3. I'm going by tab. Sorry. Yeah.
Sorry.
Okay.
So it starts at B5. Please, could you scroll down to B20?
Yeah.
And essentially, he summarises, this is at the high point of his evidence, his reasons for not attending trial in the penultimate sentence. He says, as I saw it, attending would simply have been pointless because I could not put forward a defence under such pressure and without being given the time to try and get representation.
Sorry, what paragraph was that?
Paragraph 43, third sentence, beginning as I saw it.
Yeah.
And then if you go back up to paragraph 15, which which are essentially the building blocks to lead him to make that assertion. He accepts, as of course he is bound to, that this is 4 lines down, in hindsight, he may not have helped his position by not attending, what's something of an understatement. But he goes on to assert that as a matter of his subjective belief, he wasn't able to participate, as he puts it, in a proper or meaningful manner. Well, it's not at all clear what that means. Of course, if he'd continued to participate in trial, he would have had an opportunity to answer questions put to him in cross-examination and to give such explanation as he was for the payments that formed the subject matter of the claim. And of course, he would have had an opportunity to explain his case as articulated in his skeleton argument. Now, as your lordship knows, a great many litigants, not just litigants in person, find the prospect of trial to be daunting and stressful, but that plainly is not a reason for not turning up, particularly midway through a trial. And leaving aside that no objectively good reason has been identified, the suggestion and the criticism made of the court that it failed to support Mr. Mehta in his capacity as a litigant in person is both unfair and unfounded. When one looks at the transcript of day 1, a fair-minded reader could conclude nothing other than that the court was extremely careful to ensure that Mr. Mehta had a full opportunity to participate in trial, and it made every possible allowance to Mr. Mehta to enable him to do so. Now, I was going to turn to the passage of the transcript which Mr. Pillai overlooked, but which your lordship picked up on, which is that you were keen to ensure that he should have an opportunity to test drive the case lines facility to make sure that he was able to use it. And he assured your lordship that he would have he said it will not be an issue. Now, what more can the court do than offer, in the course of a trial, to go through the documents and to assist Mr. Mehta so that any problems could be addressed? That opportunity was declined and the court was told it would be no issue. In addition to that, your lordship required the claimants to substantially revise their skeleton argument and to do so in very short order. And that was to enable Mr. Mehta to understand the case specifically against him. Your lordship wasn't bound to do that. That was a step which your lordship took to enable Mr. Mehta, as a litigant in person, properly to understand the case that was made against him and to have every opportunity to answer it. In addition, your lordship was very clear to Mr. Mehta as to what he was required to do insofar as he wanted to rely on evidence that had been adduced by Prime, and you were very clear with him as to the deadlines that he'd be required to meet in relation to that. He expressed no difficulty in understanding what your lordship said. He simply declined the opportunity to identify passages in Mr. Sadder's evidence and in Mazar's report. So in summary, the court was alive to the difficulties which Mr. Mehta faced, and it did everything possible, everything reasonable, to ensure that those difficulties were mitigated. Returning then to Mr. Mehta's evidence, paragraph 16 in my submission is totally irrelevant. This is effectively a rerun of the adjournment application, which has been dismissed and which is not being appealed. He's essentially saying he had difficulty in obtaining funds. Well, that's irrelevant for the purposes of the set-aside application. At paragraph 17, Mr. Mehta explains that he was effectively forced to attend the first day of trial out of necessity, but he goes on to say that he'd read the pleadings. You can see that in the penultimate line of that paragraph. Mm-hmm. And also that he wanted to explain to the court that he had not acted fraudulently. Well, the opportunity to explain to the court that he had not acted fraudulently was at trial. And so on that basis, on the basis of his own evidence, it's very difficult to see any reason at all, let alone a good reason, why he should not have continued to participate in the trial. So in summary, my lord, no good reason has been put forward by Mr. Mehta. If Mr. Mehta were correct in his contention that he had a good reason for not attending trial, virtually every single litigant in person would always be able to argue that they had a good reason for not participating in trial, because it could always be said that a litigant in person finds the trial process challenging, and it would enable them to assert that they did not subjectively believe that they would have a full opportunity to present their case. That is obviously a wrong conclusion, my lord. Therefore, your lordship should have no hesitation in dismissing the set-aside application on that ground alone. Dealing with the second and third limbs, I can take them relatively briefly. We say that the application was not made properly. There's common ground between the parties as to what the test your lordship should apply is. It's the Regency Rolls case, and it's for the applicants to satisfy you that they acted with alacrity, or as it was also put in the same case, with all reasonable celerity in the circumstances.
I never know why courts feel the need to interpret perfectly ordinary words and make them more complicated than they are.
I don't disagree with that observation, my lord. Yes, it looks like they've got out the thesaurus and looked up the word promptly and added a few synonyms. But whatever your lordship's preferred synonym, they have failed to satisfy you that they have acted promptly. It's worth noting in the Regency Rolls case that the delay there was 30 days, and the court found that that was too long. And that this was an old case, I think it was 2000, so it predates Mitchell and Denton. Now, I appreciate Mitchell and Denton don't apply directly in the DIFC, but in my submission as an international hub of litigation, the DIFC should be looking to streamline litigation, and it can draw from developments in the CPR, and deadlines ought to be adhered to without good reason.
Do I have those cases? Regency Rolls and Mitchell and Denton?
Regency Rolls, I think, is referred to by both parties.
I was wondering if I had it.
I'm sure you do. For
ZZK tab 2.
ZZK tab 2, yes. And that's.
Yep.
I'm afraid you don't have Mitchell and Denton, but your lordship will know the reforms that took place in English civil procedure, where the Court of Appeal, in a series of cases, made clear that deadlines were strictly to be adhered to, and that the old days of just turning up and saying if someone's got an arguable case, they should be allowed to pursue it, no matter how egregiously the deadlines have been breached, are long gone. And in my submission, that approach ought to inform DIFC jurisprudence as well. So in considering the delay in this case, there's a couple of points that the court should note. First of all, one can't ignore the fact that Mr. Mehta knew that the trial, or must have known that the trial was proceeding in his absence. And therefore, the very arguments that he's now relying on, he would have known about back in October. This is very different from a case where a litigant had no idea at all about a trial or a hearing proceeding in their absence. So Mr. Mehta was alive to the issue well before your lordship even delivered judgment on the 29th of December. The court is also invited to bear in mind that Mr. Mehta has previous experience in issuing set-aside applications, and so is extremely familiar with the procedure to be followed, and indeed with the strict deadlines for doing so, and in particular the requirement to act promptly. There is no evidence before the court to suggest that Mr. Mehta did not receive the judgment on the day it was handed down, the 29th of December. The only evidence in that regard is that it was emailed to him by DLA, but it's not suggested that there was any delay in that email being sent. My learned friend's skeleton argument, if you still have that to hand, at paragraph 26. makes a few points in relation to the promptness of the application.
Yeah.
Now, there are aspects of what is said here that come close to, if not, in fact, waiving privilege. I'll give the defendants the benefit of the doubt, and I'll assume that they're not waiving privilege and disclosing precisely what DLA Piper were and weren't instructed to do. But on the assumption that they're not waiving privilege, the only conclusion that the court can draw is that DLA were in fact instructed by Mr. Mehta at the time the judgment was handed down. And accordingly, Mr. Mehta had available to him all of the resources within DLA in addition to counsel. Now, it's said in 26.2 of the skeleton argument that certain unidentified members of the DLA team were on holiday. Well, that's as maybe, but a firm like DLA can be expected to deal with urgent matters at short notice. One can imagine that if a freezing injunction landed on their desk during the Christmas holidays, they would have no difficulty in turning that around. And so in my submission, nothing that's said in paragraph 26 offers any excuse or good excuse for the delay that has taken place in this case. So for those reasons, we say that the defendants have not established that they've acted promptly and that the application therefore ought to fail on that basis as well. The third limb, as your lordship knows, is whether or not the defendants have established that they have a real prospect of success. In light of the overlap with the permission to appeal application, I'll spend a little bit of time deconstructing the points that are put forward in relation to reasonable prospect of success at this stage, so that I can avoid repeating the same points in the context of the permission to appeal application. And what I propose to do is to use my learned friend's skeleton argument and to deal with each of the points that he identifies as establishing a real prospect of success. And I'll submit that they don't.
The same skeleton.
The same skeleton, we're now at, well, it starts at paragraph 58 under the heading reasonable prospect of successfully defending the claim. And at paragraph 60 to 65, the defendants advance 6 reasons as to why they say their defence has a reasonable prospect of success.
Yeah.
The first reason is at paragraph 60, and it's an assertion that the finding of fraud in the present case is, as they put it, exceptionally narrow. Well, I'm not clear what that means. It's clear from your lordship's judgment that you have regard to a wide range of evidence. There's a complaint in the judgment, which I don't disagree with, that the trial bundle run to several thousand pages. Your lordship was presented with an enormous amount of evidence, including underlying documents as well as witness evidence. And it was against that background that you reached the factual conclusion that you did. Now, my learned friend makes much of the fact that your lordship rejected certain aspects of our case, but all that goes to show is the care with which the court analysed the allegations and completely undermines any suggestion that effectively the court and the claimants were all pushing in the same direction and not scrutinising the issues properly. Now, at paragraph 60.2, which seems to be the mainstay of my learned friend's submissions, it's again this complaint that Mr. Sadder's evidence and Mr. Drew's expert report weren't adduced by the claimant. And that's a thoroughly bad point for the reasons I've outlined. Mr. Mehta's skeleton argument could not have been clearer. He was completely disavowing that material. Insofar as he wanted to contradict what was said in his skeleton argument and to cherry pick various aspects of that evidence, your lordship gave him an opportunity to, and he declined it. So it's simply not open to the defendants to make any complaint about Mr. Sadder's and Mr. Drew's report not being put before the court. I think at one stage in his submissions, my learned friend suggested that the duty of fair presentation extended to a duty to adduce adverse evidence. Well, no authority was cited for that proposition, and in my submission, it's an extraordinary proposition that's plainly wrong. Of course, a litigant in the context of a trial is not under a duty to adduce adverse evidence. And in any ordinary trial, it's very difficult to see how any evidence could be adduced on day one of trial, bearing in mind that witness evidence should have been filed several months ago. So that's another point to bear in mind, that it's not just day one of trial that was Mr. Mehta's opportunity to put the evidence before the court. He's had a full opportunity to put in all the witness evidence he wanted before trial. Now, it's paragraph 60.3, the defendants make the point that there was no obvious distinction between the fifth and sixth advances and the fourth advance. Well, your lordship's given reasons for distinguishing them, but even if those reasons are wrong or don't persuade the defendants, that doesn't matter. If anything, the conclusion to be drawn is that the fourth payments were also fraudulent, and it hardly lies well in the defendant's mouth to complain that the reasons that you relied on in relation to the fifth and sixth payments didn't also result in the fourth payment being found fraudulent. If anything, they've got off lightly, and they should be counting their lucky stars that the judgment wasn't for a larger sum. But the important point for the present purposes is that when considering the prospects of an appeal or real prospects of success, there's only one question, and it's this: was there proper evidence to support the conclusion that the fifth and the sixth payments were fraudulent? And was that a conclusion that a reasonable judge could have come to? If those questions are answered in the affirmative, then essentially the fourth payment is an irrelevance. Moving on then in their skeleton argument to paragraph 61. And this is a straightforward challenge to a finding of fact, but they say that the inherent probabilities do not support the conclusion that Mr. Mehta and Renish were involved in a fraud. And they make a number of points, but in my submission, none of those points take their case any further forward. The first point they make is that up until the alleged fraud, Renish operated a successful business and Mr. Mehta was a successful businessman. Well, this would not be the first case in which a successful businessman or a successful business have been caught up in a fraud. By itself, that tells one nothing at all. The second point they make, just while we're dealing with inherent probabilities, there's a number of points that they don't refer to, which of course are strongly supportive of the claimant's case. The first is that it's undisputed that Renish and persons connected to Renish received over $10 million for no apparent business purpose, none that's been substantiated on the evidence put forward by Mr. Mehta. Meanwhile, SBM is out of pocket by over $30 million. So as a matter of inherent probability, the fact that the defendants personally have received $10 million for no good reason is by itself a powerful factor. The other factors that your lordship had in mind were that Renish and Mr. Mehta gave up their business and Mr. Mehta fled the jurisdiction at the very time that the balloon went up. Now, I appreciate that that wasn't at the centre of your lordship's reasoning, but you did refer to it earlier in the judgment, and it's a factor, if one's considering the inherent probabilities, that points firmly in favour of the claimants and not the defendants.
I don't think, with respect, that I was intending to rely upon the problems caused by the email and then the collapse when Mr. Mehta was in India as evidence of fraud. I think I was relying upon them possibly as simply part of the background, but also just explaining how things had got to a point where the business collapsed.
I understand, my lord. I suppose the point I'm making is, insofar as the claimants, the defendants, are now saying, well, there's all part some interesting contextual background which you failed to have regard to, which, when one considers the inherent probabilities, would have weighed in favour of the defence. My point is simply that when one looks at the case overall, the inherent probabilities are at least as favourable to the claimant's case as they are the defendant's case, and so it really doesn't advance their position. The third point that they make in paragraph 62 of the skeleton is a suggestion somehow that the court didn't understand what an implied representation was, or didn't apply the correct test. Frankly, it's quite difficult to see what the defendants are saying here. I mean, the implication, although they don't quite put it in these terms, is that the court blundered into making serious findings of fraud without understanding the ingredients of the cause of action that led to that conclusion. It's a totally unmeritorious submission when one looks at the judgment in context. The relevant test, the cause of action we rely on, was set out in Article 31 of the DIFC Law of Obligations, which your lordship set out in full in the judgment. So the idea that you weren't taken to the correct test is a surprising submission when you set out word for word the relevant provision from the DIFC legislation. And the suggestion that you didn't know what the ingredients of an actionable misrepresentation are, again, is a bold submission. It's clear from the judgment. Does your lordship have the judgment to hand?
Yes, I'm just looking for the relevant bit. What paragraph?
Yes, well, the relevant provision from the legislation is paragraph 26 under the heading "The Law."
You got it, yeah.
So you set out precisely the cause of action that you needed to find in order for us to win on the fraud claim. And immediately beneath that section, you made reference to Clark and Lindsell on torts and some fairly lengthy extracts from that text, which I don't think my learned friend would suggest does not set out the relevant principles. And at paragraph 27, quite fairly, your lordship says it's trite law that a representation need not be express. I don't think my learned friend disagrees with that, but what he does is rely on what you say in the penultimate sentence, that it all depends on the particular facts and circumstances. Well, I don't think there's anything between us on that. Of course, it depends on the particular facts and circumstances, and in the particular facts and circumstances of the 5th and the 6th payments and their accompanying representations, it's clear from the judgment that you were satisfied that the relevant representations had been made, had been relied upon, and that there was no honest belief as to their truth, so far as Mr. Mehta was concerned. And I don't need to go over this in any further detail, because I think your lordship's already made clear in the course of exchanges with Mr. Pillai precisely what the representation it was that your lordship relied upon in support of the conclusion of fraud. And so it's not necessary for me to go over that ground, given your lordship's made himself clear. So essentially, there's nothing to the third point. You knew that you knew what the correct test was. You set it out in detail, and it's clear from the judgment how you got to your conclusion. Then the next point is at paragraph 63. This seems to be relied on by Mr. Mehta. Well, this is a point, if anything, that goes to inherent probabilities, but it's not a good point. Essentially, the point is that a fraudster wouldn't offer a personal guarantee because that would expose themselves personally. But that doesn't hold water in the present case, because the fact is that Mr. Mehta has not paid a penny under his personal guarantee in circumstances where the contract claim, which engages the personal guarantee was determined against SBM in 2021. So Mr. Mehta's exposure under the personal guarantee means nothing because he's shown himself unwilling to honour it. And if anything, it's a point against him. Paragraph 64, this is also a bad point. Again, what's being suggested is if they were really fraudsters, they would have maxed out the $10 million Forex facility and would have reclaimed their $3 million facility, as well as maxing out the $30 million uncommitted trade finance that was to be provided under the facility agreements. But there are two short answers to both of those points. It's common ground on the pleadings that the maximum sum that could be drawn down under the facility agreement as a whole was $30 million. And you can see that, you don't need to turn to it, but it's the defence paragraph 7 and the particulars. Sorry, it's the defence paragraph 5 in response to paragraph 8 of the particulars. So there was no additional $10 million under the Forex facility. That fell within the 30 million. And as to the second point that Mr. Mehta could have taken back his 3 million deposit, it was actually a condition under the facility agreement that 10% of the sum drawn down at any time be held on deposit. So it wasn't in fact open to Mr. Mehta to withdraw that sum. And just for your Lordship's reference, you see that from clauses 1.1 and 16.1b of the facility agreement. So the fifth point is just a thoroughly bad point on the facts and on the party's pleaded case. The final point that's made in support of the suggestion that this case has a real prospect of success is at paragraph 65. And I don't really understand this point, I have to say. It seems to be suggested that because Prime dropped out of the picture after settlement and you didn't make any findings against them, it follows that you found that they were not involved in a fraud. That's not the position at all. The court made clear it was making no findings in either direction in respect of Prime. Prime was no longer a party and therefore the court couldn't have made any findings in relation to Prime. So the position so far as Prime is concerned is effectively neutral. Now, as a matter of fact, it is of course the case that Prime was the initial recipient of monies from SBM, but for the purposes of the claim against Renish and Mr. Mehta, what's important is that Renish and persons associated with Renish were the ultimate recipients of money from SBM. And that was what led your Lordship to conclude that in the absence of a proper explanation for those payments bouncing back to Renish, it could be concluded that Renish itself was involved in a fraud, regardless of what Prime's position was.
But it was the speed of the transaction, I think, that impressed me particularly.
Yes, indeed, my lord. It was a matter of hours, if not 1 or 2 days after the monies landed in Prime's account. And you don't need to make...
I think took it out of the ordinary situation where, of course, there may be transfers between Prime and Renish, but this seemed to be removing the money immediately it was paid.
Exactly. So that it was inextricably linked to the payment from SBM because almost the moment it landed in Prime's account, it bounced back to Renish in circumstances where Renish were representing to the bank that they needed the money to pay third parties for the purchase of oil. So why on earth was the money bouncing back to them within a very short period? So it's not for me to establish that they don't have a real prospect of success. It's for the defendants to establish that they do. I've gone through each of the 6 arguments in their skeleton argument. In my submission, they don't cross that threshold. And so that's the 4th reason why you should dismiss the set-aside application. I'm going then, unless your Lordship has any questions on that application, to turn briefly to permission to appeal.
Yep.
And as you'll appreciate from the 85 pages of skeleton argument that you've received from the defendants, their strategy has been to throw as much mud as possible in the hope that some of it would stick. But in my submission, the fact that the defendants have resorted to attacking the judgment on virtually every conceivable basis merely serves to demonstrate how weak their position is in relation to it. Now, I'm going to deal relatively briefly with the 4 broad grounds of appeal. But before I do so, there are some important preliminary points which might serve to shortcut much of what's been said in the defendant's submissions.
Yeah.
On analysis, this appeal, or the proposed appeal, is concerned largely with factual findings that your lordship made and with reasons given to support those factual findings. The guidance in the White Book in that context is very clear. And if I may just remind your lordship of what we said in our skeleton argument in response to the permission to appeal application. So this is the 12-page document.
Right, hang on a second, let me find it. Is that your recent skeleton?
No, it's not, but I can give you the bundle reference. It's ZZC tab 4.
All right.
And I'd like to refer to paragraph 5 on page 3, which sets out the relevant extract from the Court of Appeal judgment in Chibani.
Yeah.
And I just invite your lordship to read those passages.
Yeah, well, I'm familiar with this approach from Scotland, a case of Henderson and McGrady and so on.
I had to defer entirely to your lordship on Scottish jurisprudence, but it's no surprise that it's
they're Supreme Court cases.
Yes, and the short takeaway points from this are that my learned friend's quite right to say that there was no oral evidence, but as it's clear from the third line of Chibani, interfering with findings of fact is also a strong thing to do where it's been where inferences have been drawn. I've made the point that your lordship has several thousand pages of trial bundle to look at. Of course, the Court of Appeal won't be in remotely a similar position in that regard. They're likely just to have the core materials rather than the voluminous documents that relate to them. And at that point, you see it's Roman 4 of 114. You had the opportunity to look at the whole sea of evidence, whereas an appellate court will at best be island hopping. And there's another important point here, which is at 115, which is that you are not under a duty, or you were not under a duty in relation to your first instance judgment in giving reasons dealing with each and every argument. This is not a jury. You're an experienced trial judge and can be taken to be cognizant of the relevant principles. And the idea that, as my learned friend suggests, that you need to spell out what a misrepresentation involves and identify what the representation was, whether it could reasonably be relied on, etc., it is really contrary to this guidance. As long as the key components of the reasoning are clear from the judgment, which in my submission they are, you don't need to go further than that. And then it's important to remind yourself of the test, although I'm sure you're familiar with it, which I've set out at paragraph 6 of the skeleton argument. And it really is an incredibly high bar that my learned friend has to set to surpass. And it's this: in relation to the 5th and 6th payments, was your conclusion that they were fraudulent, unsupported by evidence, or one which no reasonable trial judge could have reached?
Where are you reading from?
Sorry, this is paragraph 6 of my skeleton, and it's quoting from the Haringey and Ahmed judgment, another Court of Appeal decision.
Well, I see the reference to Haringey, but I don't see anything. I don't see what you've been reading.
I'm reading from paragraph 6 of my skeleton argument.
You say that. Which skeleton are we talking about now?
The one we've just been looking at.
My paragraph 6 begins, accordingly, the appellate will only interfere.
Exactly.
Wrong.
The words I've quoted are quotes from the Haringey judgment.
Yes, but then you went on to say Well, anyway, carry on. You
Yeah.
make your point.
So there are two alternative ways in which my learned friend can get home. One is to say that your conclusion that the fifth and sixth payments were unsupported by evidence. The second way in which he can get home is to say that your conclusion and reasoning was one that was frankly so mad that no reasonable judge could have reached it.
Yeah.
And one mustn't lose sight of the high threshold that he has to surpass when considering the permission to appeal application. There's another important point in this context, which the Court of Appeal again has made clear, which is that if it's suggested that the reasons that you gave in your judgment are unclear or require elaboration, parties are under a duty to go back to court and raise that point. Now, I appreciate Mr. Mehta was a litigant in person initially, but he wasn't when the judgment was handed down. And if a serious point was to be taken that your reasoning was unclear or that there were gaps in it, what they should have done is written to your lordship and said, please, would you explain paragraphs X and Y, because it doesn't appear to constitute a full cause of action in misrepresentation or whatever it may be. But more importantly, for present purposes, at this hearing, and in the judgment that your lordship writes consequent upon this hearing, there is no reason at all why you cannot elaborate on the reasons that you've given in your first judgment in the way that you did in exchanges with Mr. Pillai. And if you consider there to be any merit to the suggestion that there would be benefit in some of your reasoning being filled out slightly and stated with greater precision, that's not my submission, but if your lordship were to reach the conclusion that there is an arguable case that further reasons needed to be given, there is no reason at all why your lordship could not set out those further reasons in a judgment following today's hearing.
Yeah.
I can get, well, that's clear from the notes to the white book, which I'm afraid we don't have access to, but just for your lordship's note, it's 52.21.7. I don't know if your lordship has access to a hard copy of the white book, but if it assists, I can send the relevant extract after this hearing. But I don't think it's a controversial proposition that trial judges can elaborate on their reasons.
Yeah.
Where it's suggested they're inadequate. So with those preliminary observations in mind, I'll deal briefly with each of the four broad grounds of appeal. The first ground they advance is essentially that your lordship applied the wrong test in relation to the standard of proof. My learned friend seems to have backtracked slightly from the position as it was put in the permission to appeal skeleton. I'm not sure there's actually much between us, if anything. We're agreed that the relevant standard of proof is balance of probabilities, leaving aside that this is a fraud claim, which is obviously more serious than a negligence claim. It's perhaps worth me flagging up the Otcriti case, which in my submission is
that Mr. Justice Eder?
It is Mr. Justice Eder, yes. If your lordship's very familiar with it, perhaps I don't, but it's a ZZK 116.
Yeah, it's one I quoted from, I think.
It is. But in my submission, when one reads paragraph 88 and following, it's clear then that there really is no substance to the suggestion that you applied the wrong test.
Yep.
So do you have it to hand at paragraph 88?
Paragraph what?
88. ZK 116.
Yeah.
So essentially, the points being made against the claimant were similar or analogous to those being put forward by the defendants in this case. What Mr. Justice Eder says is that those suspicions are confused. The suggestion that the standard of proof might vary with the gravity of misconduct is, in my view, based on a common misconception, and then helpfully distills the relevant principles. Only one standard of proof. And this is important. The proposition that the more serious the allegation, the more cogent the evidence needed to prove it is wrong in law and must be rejected. And third point, inherent probabilities. There's no necessary connection between seriousness and inherent probability.
Yeah.
Paragraph 89, in a very broad general sense, it may be true to say it's inherently improbable that a particular defendant will commit a fraud, but it all depends on a wide range of factors. So this is all background noise and a distraction, my lord. The question really comes down to, on the balance of probabilities, was it open to you on the evidence to draw an inference that the 5th and 6th payments were made pursuant to fraudulent misrepresentations? And your lordship's conclusion was clear. You described the inference as irresistible. It's also been suggested that you reversed the onus of proof. That's a complete mischaracterization of what your lordship did. The fact is that it was common ground that monies bounced back to Renish and persons connected to Renish. Of course, that then calls for an explanation. That's not reversing the overall burden of proof. It's no different to a defendant who's caught with a murder weapon to explain why that weapon is in their possession. And if they can't offer an explanation, well, that's obviously a point that can be used against them. That's not reversing the overall burden of proof. That's just an example of how the evidential burden can shift as a trial progresses and as evidence emerges. And the fact is that even now, Mr. Mehta has been unable to articulate any coherent explanation for why Renish received those monies, let alone support that explanation with evidence. All he says is that it's the ordinary course of business. So, although ground one is dressed up as a point of law, no doubt with a permission to appeal application and the tests that the defendants have to satisfy firmly in mind, it amounts essentially to a different way of attacking your lordship's factual findings. And in my submission, it has no prospect of success. The second ground, I think I've already dealt with, and I don't think I need to say anything further about it unless your lordship wants me to.
Remind me what it is.
Sorry?
Remind me what it is.
Essentially that you didn't apply the correct test for an actionable misrepresentation.
Yeah.
I'll just check that covers how it's put in my learned friend's longer skeleton argument. Yes, it's that you failed to identify and apply the correct test in determining whether there was any actionable misrepresentation. But I've already dealt with that and explained how you cited the relevant provisions and had them well in mind. The third round is that essentially your conclusions on the 5th and 6th payments are inconsistent with the conclusions that you made on the first 4 payments. But as I've already explained, the appellants are approaching the matter completely the wrong way round. The issue that we're dealing with now is not whether your lordship was wrong to find that the 4th payment wasn't also fraudulent. It's whether your lordship was correct in finding that the 5th and 6th payments were fraudulent. And I've told your lordship what the test is for that. It's whether it's unsupported by evidence or a conclusion that no reasonable judge can reach. And in my submission, one only needs to ask that test to make clear what the answer to it is.
Yeah.
The fourth ground is essentially a make weight, and it's really another way of dressing up the arguments in support of the adjournment of the trial, which is it was all terribly unfair. Mr. Mehta didn't have an opportunity properly to present his case. There's just a couple of further points that I'd make in relation to that. The first is that as the trial judge, you didn't come to the matter completely fresh, not having a clue what the defendant's arguments would be. You were also the judge who dealt with a contested set-aside application several months earlier, in which the defendant's defence was articulated in considerable detail by the court and scrutinised by the court. So you came to the trial already having had the benefit of a lengthy set-aside application. Added to that, you had a very detailed 29-page skeleton argument from the defendants that set out their case, again, in some detail. So the suggestion that their presentation was infringed is somewhat artificial in circumstances where the arguments on behalf of the defendants had already been very fully articulated. But leaving that to one side, one struggles to see what further steps could or should have been taken either by the court or by the claimants. Now, I'm not going to refer to it, but if you look at the transcript on the 6th and 7th of October, as a fair-minded observer, one cannot conclude other than that the claim was subjected to intense scrutiny. Mr. Reid was hauled over the coals on a number of occasions on various points. This was not a case in which the court was simply rubber stamping submissions that had been made by the claimants. Each and every aspect of the claim was considered with some care, and likewise points that might have been made on behalf of the defendants. And for the reasons I've already explained, that the repeated suggestion, which seems to be the mainstay of the defendant's case, is that we should have somehow identified Mr. Sadder's evidence or passages in Mr. Drew's report that were helpful to the defendants, is simply not an argument that is open to them in light of what was said in Mr. Mehta's skeleton argument. So for all those reasons, in my submission, permission to appeal should be refused. And unless I can assist your lordship further, those are my submissions.
Yes, thank you very much. I'm just going to ask Mr. Pillai if he has any points that took you by surprise that you need to come back on. You're muted. Mr. Pillai, you're muted.
Sorry, my lord. Can you hear me now?
I can hear you now, yes, thank you.
I'm afraid that I might need 10 minutes. I could rattle through it now if your lordship could face it.
Yes, well, 10 minutes will be fine. I know genuine reply points rather than repetition.
Oh. Sorry, my lord. My screen has gone blank for some reason.
I can see you.
You can? Okay. Everything is.
Are you happy to continue without being able to see other people?
My screen's gone blank in the sense that it's all gone dark, so I can't see anything, including the notes that I've been making. Would it be possible to have 5 minutes to try and restore this, or otherwise I could try and crack on?
No, have 5 minutes.
I'm grateful.
We'll resume at 10 to 1.
Actually, my lord, it's come back now. If you want to carry on.
Okay, let's carry on.
Let's go. Okay. My lord, the first point I want to deal with is in relation to trial, whether there was attendance at trial, because my learned friend raised for the first time some earlier order. Whether a trial has happened or not is not set in stone by an earlier order. Prime settled and the circumstances changed. In fact, your lordship's order of the 4th of October says that trial would commence on the 6th of October. I can take your lordship to that, but it's in the main bundle. I can give you a reference, perhaps, if that's easiest. It's C/.
I'll find it.
Okay, C/37/141. And relatedly, in relation to when trial was starting, I think we went to the transcript and Mr. Reid himself had said that Rule 35 would apply, and that's all premised on non-attendance at trial. So we say that that point is bad. There was a point raised in relation to Mr. Mehta's skeleton argument and how he had disavowed or said he criticised aspects of Mr. Sadder's evidence and Mr. Drew's evidence. Firstly, if you read that, it's plainly not the considered work of a lawyer, nor is it really in coherent English. But it's plain that, my lord, on the 3rd of October, when your lordship and Mr. Reid were discussing the position, it was evident to both of you as legally trained that there was points in that evidence from Prime that would help Mr. Mehta's position. That's why you're expressly expecting him to identify it and give it to your lordship. So the suggestion that it would all be scratched or would not be relevant to your lordship's consideration of SPM's claim, we say it is not appropriate and it's plainly wrong just on your lordship's own analysis. What then didn't happen on the 6th and 7th, I'll come to it, but was that those points were then not raised. All of this, though, of course, goes to highlight matters as to why there's a real prospect of success. As to criticisms that I was forced to make in relation to the transcript and the court's treatment on the 3rd of October, all I would say is this is not a case of generalities of people, of anyone being able to run these points. These points are very specific as to how this was and how it appeared as at the 3rd of October when there was this last-minute settlement. You're not dealing, my lord, with generalities. The specific facts are what meant that, mean that there's a good reason here. As to promptness, the Regency role's timeframe was 30 days. We, of course, fall within that, something like 21 days. Each case, though, my lord, turns on its own circumstances. My learned friend raised Mitchell and Denton's. None of those cases apply here. Those relate to relief from sanctions where a court deadline has been missed. There's no deadline here, only that, as your lordship said, we have to act promptly. My lord, also, as regards DLA's role, they were not instructed to deal with anything other than contempt as of the 29th of October. There's no question of waiving privilege here. Mr. Mehta explains it in his evidence at ZZB/3/10. It's paragraph 12.3. So there wasn't anyone instructed to deal with this and paid to deal with this as at the 29th of October. But anyway, there was no delay. That was done promptly. There was, in relation to the scope of the trial before your lordship, Mr. Wheel gave the impression that, firstly, that there was a sea of evidence before your lordship, which there was, but also that your lordship went through all of it. That's not right. Your lordship's judgment at paragraph 22 explains the position succinctly. Your lordship said the documents filed for the purpose of the trial ran into several thousand pages. In the event, very few were referred to. The witness evidence was also relatively limited. So the idea that it appears the impression Mr. Wheel sought to give was that there was a full panoply running through all of this, my lord, and therefore that an appeal was impossible, is wrong. My lord, as to then the suggestion that this is an appeal on fact, grounds 1 and 2 are legal tests. We've identified the shortcomings on the legal tests applied both on dishonesty and on relation to the implied representations. So ground 1 is about the failure to assist the court and therefore the court's failure to consider the inherent probabilities. That's set out in Octocrity. There's no dispute about that, therefore it's being part of the test. It didn't happen. Ground 2, in relation to the test for the implied representations, my learned friend seemed to suggest that it was all before the court. It wasn't. Firstly, Article 31 sets out the elements of the cause of action. There's no dispute that was taken. That was before the court. But what wasn't before the court was the proper test for implied representations. My learned friend referred to extracts from Clark and Linsell. None of those set out the test for implied representations. And if they did, no doubt Mr. Will would have pointed it out to your lordship. And while ground 3 relates to a factual analysis, it's one that in this case, on these facts, can properly be advanced because the reasoning was wrong based on the evidence available and the factual conclusion. So it was not a reasonable outcome. And my lord, part of the reason why your lordship, we say, was led into error was because the full position was not raised before the court because of the breach of the duty of fair presentation. And the final point, my lord, relates to fair presentation. It's treated in a very high-handed manner, which we don't understand, and that may well explain why it was breached. It appears that the test is conceded, and the formulation from CMOC that I took the court to. The usual way in which one would explain how it was complied with would be to identify the sections in a transcript and so on where the relevant defences were pointed out to your lordship, but that didn't happen. The fact that your lordship asked questions doesn't mean that the fair presentation obligation on counsel was met. And the suggestion there were debates between the two of you, it doesn't get them far enough. And the scope of the duty depends on the facts of a given case. Of course, we don't say there's a blanket duty on all represented parties facing litigants in person, or facing one-sided trials to adduce evidence that goes against them. Of course, that's not right. But here, what had to happen, and I took lordship to CMOC, and also it's in the Braspetro decision of Mr. Justice Cresswell. What happens is that you have to raise the points that ran against SBM's case. And that involved here points that were in Prime's evidence. And my lord, of course, all of that was in evidence until Prime dropped out. And it was evidence that demonstrated weaknesses in SBM's case and therefore was relevant. And so it should have been brought up to the court as saying, well, look, this goes against SBM's case here. It's Prime's evidence, so it's not formally been adduced because Prime's not here, but it's relevant as your lordship has said, so I bring it up now. And then at that point, the court could have considered the documents, their status, and dealt with it as needed. It was within the court's power to admit that evidence, treat it as hearsay or adduced or otherwise. But the core point, and it's a low point that I need to point out, is that they should have said, this goes against my case. It's easy, my lord. And it's something that one sees counsel do, and it's the sort of thing one then sees in judgments that counsel properly raised this, and I considered it and dealt with it as follows. But that didn't happen there. As I said, this is a case where the boot was put in and they kept stamping. Well, the final point then is as to where this goes. We say it's not right to augment or update the judgment now that it's out there. The court should deal with each application. We say it should set aside or give permission to appeal. And the consequences if the relief sought is not granted, we say is that there's a serious fraud judgment where a defendant wasn't heard and has given strong reasons as to why an appropriate remedy should be granted at this stage. Mr. Mehta has apologised for what's gone in the past. The lordship is facing the position as it is today. Nothing else to say.
Well, thank you. Thank you very much then. That concludes the hearing. I'm grateful to both of you for having confined your submissions to the course of the morning, and I'm sorry about the technical glitches at the beginning. But thank you very much, and I'll give you a judgment as soon as I'm able. Thank you.
Good afternoon.
Good afternoon.